She entered a plea and this was for evaluation, is that correct?
Judge, this is actually a compliance hearing for an outcome for felony drug court.
I don't know, I just have a blank sheet of paper. Let me see.
Here you go.
Thank you.
That's the outcome. Sorry, Judge.
Sure, no problem. All right. So she has already entered a plea. And she was rejected from felony drug court. All right, so they're saying that you don't have stable housing. What's going on with you?
So I stay right now where I can stay. I recently just got a phone because I had to get a brand new phone. My ex has all my belongings and I personally don't want to he lives on the property where I'm not supposed to be. And so I don't want to have contact with him or go to the property or send anybody there to get my belongings. So I've been trying to figure that out. I did speak to my probation officer and he said that he would try to work with me to see how I can
Just
get
a
my
moment.
belongings.
Can I get the steps on this case? We have Odyssey now, so everything is supposed to be electronic, but they don't have the manpower to put everything in the system. So none of your information is in the system. So is there a reason, because I see here that they were trying to contact you through your parents?
Yes, so as soon as I got a phone, I was made aware of that from my mom and stuff that
I'm talking to Mike because probation cannot hear you.
so I was made aware that that they wanted me to show up and stuff. So I was trying to figure that out too, and I had talked to my probation officer, but he told me that he wanted me to focus on just showing the court first.
So who are you living with? Where are you staying?
So right now I have been just pretty much staying in hotels and things like that. But because I don't have access to my ID or social security card.
So how are you affording hotels?
So it's getting paid through my dad right now because I do have job offers, things like that, but the thing is I don't have access to my ID or social security card.
So why are you not staying with your dad?
Because he lives in Wisconsin right now.
All right, so why are you not staying with your mom?
All my family stays in Wisconsin. The closest family members that I do
Oh,
have is in Boston. But I don't want to do anything else.
All right, just a second. So here's the thing about Odyssey. If Odyssey is not going to have the stipulations on file and paperwork is missing, I don't even know why we have Odyssey. Like, I have nothing to go on with regards to this case. I know there's no contact orders in place with you.
I'll print out the judgment.
No, I just need the stipulations. I don't need it.
Stipulations and into this. Looking at me.
Does anybody have a police report?
Judge, I'll do right now.
All right, thank you. If you could just email it to me.
Okay.
And counsel, what's being emailed to me is what would have been what was in the stipulations.
Judge, may I
Yes.
give you another update while you're waiting
Yes.
on that? Ms. Miravente was supposed to have some TAP evaluation conducted while she was in custody. And if she was not accepted into felony drug court to follow the recommendations of the TAP, she was released without having a TAP, so we did not get to the TAP.
All right, let's do this. If you're drug tested today and you're gonna get drug tested today, what are the results going to be?
Have nothing.
All right. So let's get our drug tested today.
Okay, and I just wanted the court to be aware that we did complete the mental health evaluation and she was all clear there.
All right, so you're gonna do a drug test today. And then we're gonna come back and counsel, then at that time, the court will make a ruling on this and what should be done. And then hopefully by then, we will have something on your case. Okay? So if you'll talk to Miss Abrams is going to tell you where you need to go for your drug test, okay? And then after you've completed your drug test, you're going to come back here and that drug test, you're not going to be charged for it, okay? All right, thank you.
When do you want us to come back, Judge?
As soon as she finished her drug test, it's the location where she's getting the drug test, it's near the Bexar County Jail. And then she'll come back and we will have the results
Today or tomorrow?
today.
See you tomorrow.
Kylie Brooks. Who's the attorney? Okay,
Judge, you have the supplemental report as well as, of course, some of them right there.
everyone, whisper. Yes,
We're coming before the court to ask for permission for Mr. Brooks to have permission to go to Spokane, Washington to live. Currently he is unhoused and he only has his father here who doesn't really necessarily want him to live with him. In Washington, he has stable living plans to live with his mother. He has a job waiting for him. He has already been accepted, from my understanding, to Spokane, Washington, through the ICOT system. The state has no objection to him going.
okay. All right, so this is what will end up happening. You'll be transferred to Spokane, Washington, but that officer will give the court updates. And if you violate your conditions of probation there, what will end up happening, they'll ask for you to come back here because a motion will be filed. They'll let us know. And you'll have to come back here to answer for those charges. Do you understand? All right. You're welcome. Do you have any questions?
No, just thank you.
Oh, you're welcome.
Thank you for your.
Oh, you're welcome. I do my best. I try.
But you
All right, good luck to you. If you ever need anything, please let us know, okay? All right, thank you.
Morning, Your Honor.
They were right in that assessment, but things were addressed, and I believe defense has brought things and will bring things to the court attention.
Thank you.
Yes, what do you want to bring to my attention?
Judge. You have-
America, the land of medications.
From the VA, Judge.
Well, everybody needs to get a second opinion.
Yeah, my client, Mario Hernandez, Judge, dear friend of mine for many years, doing this pro bono rather. Mario is a US veteran, saw combat, going through the VA for many things. Unfortunately.
Well, make sure you get a second opinion.
We'll deal with all the allegations of this case down the road, Judge. Unfortunately, there was an accident which caused.
No, I'm telling you, I am serious. I know sometimes that when you go to the VA, people are just accepting, but you should always get a second opinion. And I don't know why with the VA, it's as though you can't get a second opinion because you have to stay in that system. So just make sure you get a second opinion. Write your legislature, write your congressman to say, hey, I would like to get a second opinion because that's a lot of medications.
I think, why don't we just let him address the ankle monitor piece? I'm okay with him addressing it, Judge.
What is going on with the ankle monitor?
My foot, it gets swelled up. And then I can't really function.
As well as because of the diabetes.
Yes, and I'm diabetic, I have high blood pressure, sleep apnea, I mean, it's been real bad.
All right, and so let me ask you this, and this is just for me to understand.
Yes, ma'am.
So the VA will give you medication, right?
Yes, ma'am.
And then you'll have some sort of bad reaction to that medication, and then they'll give you some medication to take care of that. And then something else will happen with that, and then they'll give you more medication.
Yes, ma'am.
But no, I'm very serious. Make sure that you get a second opinion.
I have been trying, and last time I talked to this, one of the pretrial officers about removing the.
No, I mean,
One of the
it's that-
just to fucking get MRI, my shoulders, and they couldn't do it. It's been.
Guess
I've been
what?
Dealing with this for 10 months.
Here's the thing about that. There's a legislator right here. He's your attorney. Say, hey, I want a second opinion. I need to get my shoulder. I still don't understand why, when people are trying to get appointments with the VA, it's months.
Yes.
And you're supposed to be in the military. Everybody wants to wave the flags. We love our military, but then it's not shown. So your legislator is here.
Need a promotion, Judge, to the United States Congress.
Yeah, you can talk to him and say, hey, I want to get a second opinion. All right, I understand your issues that are going on, and I understand that when you have diabetes, that will skew any tests that you have for the alcohol. So I understand. With regards to the monitor, you have to be monitored some sort of way.
Yes, Your Honor, but like I said, I haven't had a drop of alcohol since the accident. I mean, since then, I haven't touched anything. I'm not doing anything wrong.
No, I
I'm trying
understand.
to work, and I couldn't work.
Here's the thing, I understand what you're saying, but legally, the law says, and he will tell you, the law says you must be monitored by some sort of alcohol device. So what you need to do is speak with your pretrial services officer, and I will send them an email also if there's no objection, and let them know what all of your issues are, and let them know if there is some other device that they can recommend for you. And if there is another device, I think now they may have started the wristwatch or something, or the blow. So talk to your pretrial services officer, see if they have something that's in your price range. And then your attorney can speak with the state and see if they have any objections to it. If the state has no objection to it and you're being monitored, I have no problem signing it, okay?
Thank you, Judge. And Judge, just to be clear, the reason he was on the ankle monitor for some time, he wasn't driving at all because of the injuries that had occurred during that incident. So possibly we'll talk to pretrial, as you suggested,
Yeah.
see if we could get placed on it in condition and all of it.
Yes,
Because he's not, I know him
Yeah.
very well.
yes. So if you contact them, and I'll take that matter up. And you all are about to go in session again?
Monday, yeah.
Yes. All right. And how long do you think this session will last? You have any idea?
They're 30-day sessions, Judge, but unfortunately our illustrious governor has added redistricting, so if things don't go well, he'll call it again and again and again like they did last time.
All right. So Ms. Ferguson, what I'll do, I'll set this in 35 days approximately, and then we'll see where we are.
Yes, Judge. And if I need to file it, I wanted to come in. I didn't want to file a legislative continuance right now because I didn't really need it when it was dark.
All right.
I'm allowed to, but I didn't want to do that. I wanted to come in and address this with Mr. Hernandez. And to come see you, because it's been.
Well, it's always good seeing you. All right, so we're gonna bring you back on August 21st. Once you sign the reset form, you're excused, okay?
Okay.
Thank you.
All right, thank you. And again, second opinions, it should be standard for you're allowed to get a second opinion and even get a second opinion outside the system. But the only way you can do that, I've discovered, is you should write your legislature, email your congressman or whoever that is, and tell them, hey, hey, I want to get a second opinion, and my appointment needs to be now. It can't be 4 months, 5 months in the future.
That's correct. Yeah, because I was in the emergency room last month for my shoulders. And I don't have an appointment with the primary until September 20th.
Because my thing is, either we love our troops or we don't. It's nice for TV to say you love your troops, and what are you doing? All right, sir, once you just have a seat, thank you for dressing appropriately for court. They're going to give your attorney the reset form. Once you sign the reset form, you're excused.
Thank you.
And I will send that email to pretrial services.
Thank you.
All right,
Appreciate it.
thank
And
you.
excuse me.
Yes. Sherry Dye. And Tiana Chessman.
Yes, Your Honor.
All right, this is Is this family violence? All right, so there's a motion to travel. Is this correct?
Yes, Your Honor.
Are you ready to proceed?
We're ready.
All right, the court is calling NIMAG number 756623, State versus Tiana Cheeseman. Can I have parties announced for the record for the state,
Rick Daniel for the state of Texas.
for the defense?
Terry Dye on behalf of Tiana Cheeseman. I'm present. She's present. We're ready.
Are you Ms. Cheeseman?
Yes, I am Mrs. Cheeseman.
All right. So it's a court's understanding defense that you would like for her to be able to travel. Is that correct?
That's correct, Your Honor.
And this case has not been indicted. Is that correct?
That's correct.
And how long has this case been pending, state? Do you have an offense date?
Yes, I'm trying to. It looks like it's been pending for a little over a year, March 20th, 2024.
All right, this has been pending since March 2024, over a year. So state, do you have any objections to her traveling?
At this time, yes, given the nature of the charge, the facts that are involved with the charge, the injuries that the child sustained from this defendant. And unfortunately, given the fact that at this time we can't confirm for sure the whereabouts of the child, we would object to this.
All right, and state, I know you're not in charge of indictments or tendering cases to the grand jury for indictment, but this hasn't been tendered to the grand jury in over a year?
That's correct.
All right. So Ms. Cheeseman, can you raise your right hand for me, please?
Yes,
Please let me swear affirm the testimony you give will be the truth and nothing but the truth, so help you God.
yes,
You can lower your hand, state your name for the record.
Tiana Cheeseman.
All right, Ms. Cheeseman, the complainant in this case is a child.
It is, yes, sir.
Have you had contact with the child?
Yes,
All right, has the child been placed back with you?
yes, with supervision.
And is that supervision through Child Protective Services?
No, everything with Child Protective Services was closed out as of October of 2024.
Oh. So we were here on August 1st, 2024. The case still had not been indicted. And there was an agreement that the defendant was to have no unsupervised contact with minor children. And she has not violated that. She's still having supervised contact. So state, do you have any proof or evidence that she's having unsupervised contact?
At the moment, Your Honor.
All right, so where would you like to travel?
So I was supposed to be traveling to New Orleans, but that trip has now expired. Next will either be Dallas, Fort Worth, Texas, and Houston.
All right, and what would be the travel permit? What is the purpose of the travel?
Medical conferences, because I'm a nurse.
All right. Anything else from either side?
Yes, Your Honor. I would just like to offer to the court. I did provide Prosecutor Ashley, I apologize, her last name is escaping me. I did provide her with a certificate of completion of my client's parenting class and a closure letter from the CPS caseworker. I personally, as an officer of the court, will represent. I spoke with the caseworker. She had no concerns about Ms. Cheeseman. And stated that it was her understanding that her husband would be there. I'm not sure why the state is saying they can't confirm the whereabouts of the child, that the home has remained the same for the child the entire time.
All right, this is what the court is going to do. The court will allow the defendant to travel for purposes of medical conferences or her employment. The court will note that the Child Protective Services case has been closed. And there's to be continued no unsupervised contact with minors. Is there anything else?
Your Honor, the court did grant my client the ability to perform the duties under her job when she sees children for work purposes. That was addressed previously in this court.
And the work purposes with regards to employment?
She's a nurse.
All right, but she's a nurse that she is supervised by other doctors, correct?
Yes, Your Honor.
Is that correct, Ms. Cheeseman?
Yes, yes, it is.
And the doctors are aware of this offense?
No.
All right. So she needs to be supervised by doctors and they need to know the fact that she has this pending case. Because she's a nurse and it should, according to licensing, this is something that should be told to her employer.
And Your Honor, in,
And state, this has been pending for a year.
I will
So-
have with intake today, as close to the top list as they can to present.
All right, and counsel, you want to say something?
yes, Your Honor. Ms. Jackson was the previous prosecutor on this case and had not given those directives or instructions, and we were trying to work out something prior to her departure from the office. And so I made Ashley aware of that today so that hopefully we could work out some resolution in this matter.
Ashley Jones for the record, Your Honor.
Yes.
Just for the court clarification, at the last bond hearing on August 1st of 2024, I did go back and review that, and the court did allow the defendant to still continue to have the children at her job. And so at this time, the state's not asking for any different orders other than that prior hearing.
Well, she needs to be supervised. And my understanding is that her employment, she's supervised by doctors.
Yes, Your
All right. All right, is there anything else?
Nothing from the state.
Anything else, counsel?
Nothing further.
All right, thank you.
All right, thank you.
Thank you. Have a good day.
You too.
Ruben Apreciado. Hello.
Morning, Judge.
Good morning. Where's your client?
He is not here, Your Honor. He has another setting county court as well.
All right. Deputy Laura, could you make an announcement in the hallway for Ruben Apreciado, please? Yes. I know I'm mispronouncing it. Court is calling 2025 CR 006431, State versus Ruben Apreciado. Could I have parties announced?
Deputy Pitlock for the state of Texas, Your Honor.
Tiffany Seattle for the defense.
All right. This hearing was scheduled at 9 a.m. The defendant did not make an announcement at docket call. It is now 10:59 a.m. Counsel, have you had any contact with your client?
I've not been able to get him, Your Honor.
All right, Deputy, did you make an announcement in the hallway?
Yes, ma'am.
All right, State.
The state would kindly ask for a bond forfeiture and to issue a warrant, Your Honor.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. Have a good one.
Maybe excuse?
Yes. Ruben Renteria. All right, good morning. So what is happening with this case?
Your Honor, if you recall, this is a case where Mark Lapovius was a retained attorney in charge. I believe his office had filed a motion for continuance. My client's also expressed to me that it looks like his office can be taking over the remainder of the cases. Well, it hasn't happened right now. But we would like to get a little more time. It's my understanding that they're going to be in special session once again.
All right, I am recalling this for tomorrow. If they are not on his case by that point in time, we're going to proceed.
Okay.
On whatever case is remaining.
Okay.
All right, Ms. Ferguson, on Renteria, recall it for tomorrow. Oh, tomorrow's Friday, isn't it? Everybody's piping up. They're like, yeah, it's Friday. All right, recall this for Monday.
Yes.
All right, we'll have you back on Monday.
Thank you.
Thank you. Antonio Garcia. So we have an interpreter?
No.
Yes,
That's one.
I'm here.
Oh, that, not the.
All right, so it's not the interpreter on this case. Okay.
Next one, Judge.
And which one is that?
We'll have the interpreter on Mr. Aguilar's case, Mr. Garcia's.
Hector Aguilar?
Yes.
All right, then just step back. Let me do that because we have to get the interpreters out.
Aguilar?
You're welcome. All right, this is Hector Renee Aguilar.
It is, Judge.
This is family violence?
Yes, Your Honor.
Okay. All right, so this is final discovery. Where are we?
We've got all our discovery, Judge, and we've got a plea bargain offer. We're not prepared to accept it right now, so we're asking for a plea deadline.
All right, sir, how old are you?
I'm 27 years old.
All right, Ms. Ferguson. Set this in 3 weeks for a plea deadline date. And I'll need an acknowledgement of discovery before you all leave today.
Yes, sir.
All right, so you're gonna be back on August 7th. At that time, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date will be a jury trial. Do you have any questions about anything?
None.
All right, thank you.
Gracias.
Thank you.
You're very
Do
welcome.
you need me to sign anything?
I do. I completed with the other case. Is that
All
okay?
right, no problem.
Is that? Yes, no.
All right, Deputy Laura. Mr. Aguilar is complete. All right, so you may have a seat. Want to tell him oh, you all were there? We're done. And if you have your other client come back up, please. All right, Antonio. Hello. All right, so on this case, again, discovery, do you have it all?
Yes, Judge, we did.
Okay.
We're in the same circumstance.
Then we'll come back on August 7th for a plea deadline date. All right, state on Antonio Garcia, if you can do acknowledgement of discovery.
Yes, Judge.
Once you sign the reset form, let me find you on the docket first. All right, once you sign the reset form, you are excused. Thank you for dressing appropriately for court. Joseph Alaman.
We're here, Judge. Come on up.
Oh,
This is confusing.
oh, and you know what, can you have them pull her file for me again? Let me see if I have it. Yes, I don't have it anymore, so if they could pull it again. Thank you. All right. And you're Joseph Alaman?
Yes, yes, this is my client.
Okay. All right, so we're here for Discovery Council.
Yes, Judge, we're, the discovery, and there was another case that was hanging out, as regards to the second case, we don't think it's gonna get filed, so I'm not worried about it at this point. We did receive an offer today, and we have received discovery. I need to, go over with him what the offer would mean. It's a prison offer and everything, but, we should, be ready to go by next time, Judge.
All right, how old are you, sir?
21.
All right, Ms. Ferguson, recall this for 3 weeks for a plea deadline date, please.
Your Honor, I'm gonna be out of the country,
When?
but I'll get with her. So next week, we had a death in the family. I'm flying out Monday through
Right.
19 years old. He didn't wake up. I don't know what that aerospace engineering at MIT. We don't know what that. Just
Oh,
so yeah, so that came up next week, and then Judge, the following week, I'm headed to Alaska for 2 weeks.
okay,
But I'll be back around the 17th or 18th of August.
all right, Ms. Ferguson, can you put this for August 21st?
Perfect.
All right, your plea deadline date is gonna be August 21st.
We'll be ready by then, Judge.
All right.
I'll talk to you at the week, okay? And all that stuff. All right.
We'll have to back up to the bottom.
Mark, take care of yourself.
Adam?
You know, Adam, yes, I'm sorry, Adam. Adam, Mark.
I was
yeah.
like, I mean, he was healthy, soccer player, and he talked to his mom, everything was fine, just went to sleep. And I mean, I don't know, they ruled out overdose, they ruled out suicide, they ruled out homicide, so the autopsy is gonna, I don't know.
Oh my gosh, I'm so sorry to hear about that.
They have affected parts in the family, sadly, you know, it's funny, thinking suspicion that's what happened.
Maribete? Hello. So I'm glad you tested clean. That's the first step, right? So I want to make sure that you're clean and healthy. Now, the next thing we need to do is we need to try to get you stabled on housing and everything else. So have you been able to talk to someone about housing yet or no?
Yeah, I did have a friend of mine that said that, she could try to help me out with, a program or something, or, a job too, but the thing is, like, she, again, like, told me about the social security card and ID, so I'm just trying to figure out how I can get that, so that I can get started on the job.
Well, they do have a program. It's a nonprofit. It's called Build Better. I think Building Better. They may be able to help you as far as obtaining identification and getting license. Now, mind you, nobody's going to walk you to a specific place, but at least they can cut down on the research you have to do on how to figure out to do it. You understand?
Judge,
Yes.
in addition, she can speak to her probation officer and we can get you
Yes.
with the reentry program.
All right. So this is what I'm going to do. Do you want to set it for another compliance to make sure that she stays on track and that she has the housing and everything taken care of?
Yes, Judge, and I'm gonna give her a reporting date, for her officer.
All right. When do you want to call this back?
Judge, can you give me 45 days? I wanna see if we can get the TAP evaluation done within that 45 days as well.
All right, Ms. Ferguson, I need a,
Address the court.
yes.
Can we have the compliance hearing with her directly instead of in front of you? Because she didn't have a car. That's the big problem.
She can do it by Zoom.
Or
Yeah. So that's how it works. But I can
Yeah,
tell you
you have-
this.
For now, I just have a cell phone, but,
All right, so here's the thing. If you're not doing well, you're gonna have to appear in court. I will work with you because I understand you have transportation issues. And this is for compliance, but it's to help you stay on track. You understand?
yes, ma'am.
All right, I need a 45-day reset. All right, so it's gonna be September 8th. So you need to make sure that you're following through on everything. And if there's somebody you can't get in touch with, that's what I'm here for. Come back to the court, okay?
Yes,
All right, Ms. Abram is gonna give you the information you need and who you need to contact to help you with everything, all right?
yes.
All right, good luck to you.
Thank you.
You're welcome. Wilfredo Matei, morning. Let me just pull you up here in Odyssey, which has not been a friend to anyone today. Oh my gosh. And then what was it, Tuesday? It went down. And there's no backup. At least it appears there was no backup because we couldn't find anything. All right, so you're here for sentencing today.
Correct.
The court is calling 2025 CR 002-719 State versus Wilfredo Matei. How do you pronounce your last name? Matei. Oh, I did it correctly. Okay. Can I have parties announced?
Jason, you're here for the state, you're.
Brian Kimbrough from Mr. McKay.
All right, you entered a plea of no contest on May 22nd for evading arrest detention with a vehicle according to the plea bargaining agreement. The state will make no recommendation on your application. Punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. State is taking in consideration 2025 CR 003472 and 2025 PF 11391. Have both parties had a chance to review the PSI report, state?
Yes.
Defense?
Yes, Your Honor.
Any objection, state?
No.
Defense?
There is a correction, Your Honor, that I think will become more clear during the testimony of my client, but he does not, he is motivated for treatment, and I think there was a misunderstanding, and it says he wasn't. He was, and he is, so I'll let him explain.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Wilfredo Matei.
All right, you may proceed.
Your Honor, okay, just in explanation, Mr. Matei has pretty serious record. He lived in Utah with his mother, who's present in court, and I was gonna call her as a witness also. And they moved here really to help, for many reasons, but one being to try to get Wilfredo into a better environment. But he has a serious drug problem. I can tell you that he has told me that he is serious about changing his life and has reflected on that while he's been incarcerated. And I know he wants to explain that to the court. He has attempted to get into drug treatment while he's been incarcerated. He was communicating with various programs to see if he could get treatment at this time, wasn't able to. So with that said, could you state your name?
Wilfredo Matei.
And Wilfredo, you have been in jail now for how long?
It's been 4 months this time.
Okay. And you have a pretty serious record in Utah, correct?
Yes.
Okay. And so you've been to prison
Yes, sir.
on a number of occasions.
Yes.
And have you reflected on your situation while you were in prison this time?
Yes.
And what did you decide?
I really want treatment, need treatment, and I've been trying to do doing programs and stuff so I can show that I'm trying to change and stuff. And I've written a couple programs, lifetime recovery being one of them. And I've gotten approved, but just being incarcerated, I can't go to fifth until I get out. But, thought a lot about that, and finally opening up to my kids to where I'm really at. And mom finally told me where I'm at, and it just made me want to show them that I can get out of here and do better.
Now, you've been diagnosed with some mental health issues, correct?
Yes, sir.
What mental health issues do you have?
PTSD, anxiety, depression, ADHD,
Have you been diagnosed with bipolar?
bipolar also.
Are you getting any medication or treatment while you've been incarcerated?
Yes,
Has that helped you to sort of reflect on your life?
yes, I take my medication every day. Don't miss that.
Do you think you could succeed on probation?
I think I can.
You think that
With help with program,
excuse me?
with a program, yes, I need help, I need rehab, I really don't want to go back to prison.
Are you willing to do inpatient program as well as outpatient program?
That's the only thing I would want to do is inpatient.
The only thing you'd want to do is inpatient,
I would want to.
but you think you have a serious problem.
Yes, sir.
You believe that that problem has been part of the reason why you've gotten into these problems, legal problems.
Yes, sir.
Is there anything else you want to tell the judge?
Not turning it into you guys.
Okay.
History of me going to class, recovery and motion.
Okay.
Great.
You're welcome.
Anything else you'd like to say?
I don't know, I don't really know what to say, but I don't want to say even just left myself into prison. I know I have a history of going to prison and stuff, but I've never had a treatment program. I've never had a chance to get into a program or to a rehab or anything like that. And
I went out of my way to write Lifetime Recovery and also New Direction Church. So I can go to a ministry. And they both proved me, but it's just being incarcerated, I can't go to the program until I'm released. But if I do get released, I plan on going directly there. Like I told my family, I don't wanna make any stops. I wanna go directly to Lifetime Recovery and start the process of that process with them.
All right,
All right, I have one other witness I'd like to call. for.
just 1 second. State any fact questions or no?
No.
All right, I have a couple of questions for you. If there's no objection.
Yeah, okay.
All right, so I look at everybody as an individual. Sometimes people will come before me and their history is bad. Right? Honestly, anytime you get sent to prison, that's bad history. Your history is bad. It doesn't look good. So this is what I want you to explain to me. So in the stipulated evidence, you're saying that this motorcycle was sold to you. You have a key, okay. And then you evade, but then they say you have a bunch of keys on your person. And the police say that those keys are used to open mailbox. I think they said mailboxes. I think they said you are in possession of a set of jiggler keys. When asked, suspect stated that the set of keys belonged to a friend who is a locksmith, but did not know why he was in possession of a mailbox key. So you're riding on a motorcycle. Why do you have jiggler keys?
Because I took that motorcycle. Lied about that. I took the motorcycle. Jiggler keys were a friend's, but he let me use them because I was doing dumb stuff.
All right, and use the keys for what?
I have never used a key, but those jiggler keys, they were supposed to be to get into cars. But I never able to use them, like they're brand new keys.
All right. Okay, thank you.
Yes.
All right, you say you have another witness?
Yes, Your Honor.
Yes.
Maggie Vargas.
Mr. Matei? You're back against the counter.
Maggie Vargas. Yes, where is she?
Good morning. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Maggie Vargas.
All right, you may proceed.
Thank you, Your Honor. Ms. Vargas, what is your relationship with Mr. Matei?
I'm his mother.
You're his mother? You gotta speak up,
Oh,
so.
please, I'm his mother.
And when did you first come to Texas?
They're gonna be 5 years in November.
And you came with Wilfredo?
With Wilfred. He came after us. After he came released from prison.
Okay, and he's been living with you since then?
Yes, sir.
And why did you come to Texas?
I used to be a nurse at the University of Utah, Texas. I mean Utah. So we just wanna start over and take the kids out of Utah, you know. So we were looking for places. So I love Texas. So I said, let's go to Texas because I'm Puerto Rican. So and my family live in Puerto Rico and Miami. So it's like tropical.
Which some people don't know that Puerto Rico is a part of the United States, so thank you.
So I didn't want to stay in Utah because it's too cold and the winter is too long. So we said, let's go to Texas. So we came around here at random and just in a week we buy a house. And then we came like 2 months after that. So we said, I'm here. I've been 5 years.
Now, in terms of Wilfredo, do you believe that Wilfredo has a drug problem that is serious?
Yes, he,
You do. Did he have that problem in Utah?
yes.
And has he ever had, your knowledge, has he ever had any treatment for that problem?
No.
Now, I don't know if you were able to hear, but Wilfredo was asking the court for an opportunity to get community supervision and get drug treatment. Do you think that he would benefit from drug treatment?
He will do better because he never had a treatment before.
And do you believe that if he got that treatment and if he got community supervision, he could succeed? Do you believe that?
I believe that. I will not give up on him. I will be here for him. I'm happy.
And Wilfredo does have some mental health issues, correct?
Right.
He's been diagnosed with various things.
Bipolar, PTSD, depression, PTSD.
How old is he?
He's 29,
29.
29.
And
I
he
have a
has,
lot of kids, so. I mean,
How many children do you have? How many children do you have?
4, but I have a lot of grandkids, so they're not gonna be there for and all that. So. But we have like 4. We lost my father at the tragedy, so we lost his dad. He's been killed in Puerto Rico, and then my nephew, he just died 3 years ago by a drunk driver. And recently my grandson, he died from heart problems. So all that he's been, in all this situation, and he's been so depressed, having a lot of anxiety. I mean, I could not even breathe my own, or crying because thinking of him and just battle with the situation and all that. And I know one of the things that he's been going crazy and using drugs is because all these tragedies in my family.
Okay.
so Wilfredo is still a young man.
Yes, sir.
Do you believe that he has the potential to be a better person?
Yes, he's using, I don't know how to commit all this crime because he's sweet, he's singing so good, he played guitar, he was good in school. I don't know what's going on after, but he's not a bad person. He made the bad choices.
Okay.
Okay, thank you.
Any questions?
No question.
All right. So what types of drugs does he use? Do you know?
Amen. I'm hearing,
Do you know when he started?
I think when his friend in Utah being killed.
All right. Thank you so much for giving me insight into your son.
That's for his behaviors. I'm so sorry about that.
No, I mean, here's the thing. It sometimes parents think that children's behavior is a reflection of them. Now, if he's a 2-year-old or a toddler, that's a reflection on parenting. But at some point, it becomes our own choices, at a certain age. Okay.
I never use any drugs or nothing. I don't even drink. So I don't know why we learned that because we have a beautiful house and his house is no drugs at my house. Everybody's working. Everybody's a professional, I just want him to be changed. Yeah, for his kids.
All right. Thank you so much.
Thank you.
Amen.
You're welcome.
Thank you very much.
All right. Mr. Matei, you can come forward. Any other witnesses?
No other ones.
All right. State, do you want to continue with the offer that you have in place?
Yes.
All right. All right. So here's the thing. Your history does not look good. The state is offering you 10 and they are silent on your application. People always say that probation in this court is not easy. I mean, I guess it's not. I wouldn't know because I'm not the person doing the probation. But when I give people probation, it's designed hopefully for us not to see them again unless they're coming back to say, thank you for giving me a shot, right? So what I can tell you is I'm going to give you a choice, and I'm going to give you a choice because this is an evading arrest detention in a vehicle. I see your history, but these are the only 2 choices you have. Don't come back to me with a third choice. Don't try to do something different because you only have 2 choices. 1, I will send you to prison, and I will send you to prison for 5 years. You'll get credit for any time served. Or the second option is this will be a conviction on your record. I'm not going to grant him deferred adjudication, and I will sentence him to 10 years in the prison, suspended and probated for 10 years. Those are his only two choices. And if he chooses the second option, he's going to remain in custody because he's going inpatient treatment somewhere. So those are the only two choices. There's not a third choice. So do you need to speak to him?
A second.
All right. This is what the court is going to do. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release. There's to be no employment as a home healthcare provider or with minors. There's to be no residing with minors. There's to be 200 hours of community service restitution. How far did you go in school?
I graduated high school.
All right, there's 100 hours that will be deducted once he completes parenting classes. The remaining 100 hours will be deducted if he obtains a higher level of education or if he obtains some sort of trade school certification. There's to be field visits 1 time per month until further notice. There's to be an evaluation for DDRF. And there's to be referrals to SafeP. I'm sorry, an evaluation for SafeP. I think, just 1 second. Yes. There's gonna, just 1 moment. Strike the last evaluation for DDR. This is the order I want things. There's gonna be referral. And all of this is to take place in custody. There's to be a referral to felony drug court. If felony drug court doesn't accept him, then he is to go to SafeP. And Ms. Abrams, the referral to DDRF, how long is that taking?
Have multiple referrals going. The DDR referral process could be month and a half. What I suggest possibly is let's do the funding and report it's not accepted.
All right,
DDRF, I mean, you already said safety, right?
yes. Take in consideration 2025 CR 003472, 2025 PF 11391. There's going to be 120 sober meetings in 120 days. And let me see something else with your history. And it goes without saying, you're a convicted felon. You're not allowed to possess any weapons. Do you understand?
Yes, I understand.
Probation, is there anything else? Is there anything else you need? I'm sorry, there's to be restitution, if any, to the complainant for the motorcycle.
Brett Castillo.
All right. I'm sorry, what's the name?
Brett Castillo.
All right, that will be Brett Castillo.
And Judge, in reference to also, there's another case that's currently open, a theft 1,500 to 30,000. If I can have a moment to speak with defense counsel, I'd like to try to maybe get that resolved because that'll obviously hold them up.
Okay. All right, let's do that. Did you review the probation? Is there anything else?
With the understanding if there is any open cases, felony drug court and or safety will not.
All right, they're going to take care of that, hopefully today.
Or soon, yeah.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we're off the record. Here's the thing. You're going to remain in custody until that other case is resolved. He cannot move anywhere. I'm not gonna release him unless he's in some sort of treatment. And stop breaking your mom's heart. All right? All right, thank you.
Thank you, Your Honor.
You're welcome. Gregory Prunita? Good morning, how are you doing? All right, I don't know what's going on with what I'm receiving, just a second. I have no idea. What is this case about?
Judge, you gave him 2 years supervision.
Yes.
However, his parole got revoked. So
All right.
we wanted to provoke that probation period or so.
All right, do y'all have a motion to revoke on this?
No, Judge, so it's no motion to revoke or whatnot. I didn't have an opportunity to really understand what the parole outcome was, how long he was sentenced for, but my understanding, they were gonna ask for possibly a reconsideration of sentencing.
No motion's been filed. He was he did a 3-year stint
Mhm.
for on the 4200 charge. He paroled out after 17 months, picked up this charge and got probation.
All right, so here's the problem.
Now,
This sentence that I gave him was June 30th. Oh, we're still within the window. So what are you gonna be asking for?
Judge, I was just going to ask you. I've not seen this situation before.
What are you asking?
What, a reconsideration on his application for supervision. He's been in custody since the offense day.
Well, his minimum on this is 2 years. So you want to talk to the state and see if they have any objection, because once he's sentenced, there's no reconsideration.
Well, they had recommended the 2 year supervision. I'm sure they won't have a mind problem with 2 years to do.
I mean, you'll need to talk to them. Yeah. So once you talk to them, I'll take care of it. Okay. On Wilfredo Matei, what other case is this? I don't have the other file for it.
I have the number. He just got indicted after he took this plea. It comes out of the same fact
That's
pattern, part of the same deal. So, I wanted to bring him back either tomorrow or Monday to take care of that case.
We can do it Monday.
Monday? Okay.
Yes. All right, thank you. All right, Brian Adam Sanchez.
Judge, I conferred with with the state this morning and got an offer on Mr. Sanchez. I was hoping with some time so that I can do that with my client and maybe have him do a couple other things and see if I can't get it a little better, Judge.
All right, so you have all discovery?
I can sign off on that, Judge, yes.
All right, so state if you'll do the discovery acknowledgement.
Yes, Judge.
And Mr. Sanchez, why were you late for court?
Really looking for a partner.
All right, so here's the thing. You have to be on time for court.
Yes, ma'am.
I note that this is your first time appearing, so next time, be on time. Otherwise, what can end up happening is a warrant can be issued and you can be placed in custody. You understand?
Yes, ma'am.
How old are you?
I'm 31.
All right, Ms. Ferguson, set this for 2 weeks for a plea deadline date, please. All right, we're gonna come back on July 31st. At that time, you need to let me know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next setting will be a jury trial date. Do you understand?
Yes, ma'am.
All right, thank you for dressing appropriately for court. Just have a seat and Ms. Ferguson will give you a reset form, okay?
Okay, thank
All
you.
right, thank you.
Thank you, Judge.
You're welcome. Hello, counsel. Guidance.
I stepped out after I thought you called another case. I apologize.
Oh, no, I did. I had called another case, but we finished.
Mr. Pernada and the prosecutors, everybody agreed to instead of 2 years supervision to a 2 year sentence on this new charge.
All right. So this is what I would have you all to do. If you will just print out the plea bargain page sheet and just enter it into evidence as amended.
Sure.
And then we'll go on the record with it and then we'll sentence him and get another trial court certification.
Perfect. Thank you.
All right, thank you. Jose Sanchez. Court is calling 2020 CR 6566, and counsel, you're on this side. State of Texas versus Jose Rizzo Sanchez. Can I have parties announced?
Rick Payne for the state of Texas.
Adelie Silver for defense. And are you Mr. Jose Rizzo Sanchez?
I am, Your
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Jose Rizzo Sanchez who was placed on deferred adjudication in 2020 CR 6566 for the offense of assault, family choking, strangulation on August 23rd, 2021 for a period of 2 years? Is that you?
Yes.
State?
Yes, Your Honor, we're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation condition number 2. On or about the 7th day of June, 2024, in Bexar County, Texas, the defendant, Jose Rizzo Sanchez, did then and there illegally use a controlled substance, namely methamphetamines, in violation condition number 2.
You said on the 7th of June?
Yes, Your Honor.
I don't have a motion to revoke with the 7th of June on it.
This is the first one at the top I read.
All right. I don't know why I keep getting the incorrect motions to enter adjudication of guilt. Okay. To that, how do you plea?
True. Read the remaining violations, Your Honor.
No objection from defense, Your Honor. All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there a post agreement?
There is not, Your Honor. We're working to go open as far as our recommendations.
All right, state, what are you requesting?
We're requesting adjudicate the defendant and sentence him to 3 years TDC.
All right,
We're recommending to follow probation's recommendations.
and what is that
That
recommendation?
is a set.
All right, would you like to tell me anything, sir?
Hmm.
All right, I don't think you're a good candidate for probation. This is not your first MTR. You've had a previous MTR for the same offense. Do you understand?
Yes, Your Honor.
All right, the court is finding condition number 2 true. The court will find you guilty. The court will grant the motion.
May we talk about time, Your Honor?
Yes.
Your Honor, then in the alternative, we would like to ask for 2 years TDC. No new offenses have been picked up. He has completed status twice, aftercare once, outpatient once. And he currently has 231 days in Bexar County Jail, as well as the 2 completed status inpatient programs. Only 1 aftercare was completed.
Okay. All right. So it appears though that nothing is working with you because you're continuing to repeat the same violations.
Thank you, Your Honor.
All right. This is what the court is going to do. The court will find you guilty, grant the motion. There's an affirmative finding of family violence. There's to be no contact with Vanessa Sanchez. State, has there been any new offenses or violation of the no contact order?
Not to the state's knowledge, Your Honor.
Probation, has there been any violations of the no contact order?
Judge, on the motion to revoke, there is a violation of condition number 27. In that on the 12th day of July of 2024, there was contact or attempted contact domestic contact.
Your Honor, I would like
A
to.
family member by telephone, mail, or person. I know they claim that violation, but that is based on the
Your Honor, so that was he admitted to probation that the CW was going around to his home. There are incident reports where him and his family, since it is a family home, did call because she is returning to the home because her children do live there.
All right, this is what the court will do. The court is going to, as previously stated, find you guilty, revoke. There's an affirmative finding of family violence. There's to be no contact with Vanessa Sanchez. no residing with children, 4 years in the prison. Did you review the document entitled, and I'm sorry, credit for any time served? And credit for any time served in inpatient treatment successfully completed,
The inpatient part, Your Honor, or the aftercare part?
inpatient.
Okay.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain, I'm sorry, because this is not a plea bargain agreement, you do have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction in an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question about any of that, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, and then the court will recommend the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. However, it's there to help rehabilitate you. Do you understand?
Yes, Your Honor.
All right, good luck to you.
And he still has to ask for that when he's there as well?
Yes.
Correct? Okay.
Yes, thank
Yes,
you.
thank
Good
you.
seeing you.
Nice seeing you as well, Your Honor.
Jesse Luxemberger. Hello,
Hey, Judge, good morning.
how's it going?
Judge, I'm blessed.
Yes. All right, if you'll make sure Christine Brown gets copies of that, please. All right, so today an offer was due. Were you all able to tender an offer?
Judge, we're in negotiations. I've conferred with Mr. Garahan. And Your Honor, I just would like a 1 month reset. We want to talk to our client, like, there's a chance we could work it out, and I'd like to just talk to him and go through that with my co-counsel.
All right, Ms. Ferguson. On this case, if you can give me a 30-day reset for a plea deadline date, please.
So Judge, even like if you had anything in early September, I don't know if you do.
Sure, I understand what's going on, counsel.
Thank you.
Okay, Ms. Ferguson, if you'll put this early September.
Yes.
That's perfect.
All right, and everything's gonna go well for you. I know it.
Judge, I'm doing my best to do my duty,
Oh, no, you know what?
and thank you
The
for
key-
sharing.
Sure. You know, the key, they tell me you remove the stress, right? So it's gonna be fine.
Thank you. I really appreciate that. I always like the flowers too. It's good.
Hey, you know what? We gotta bring some beauty somewhere.
Amen to that.
All right. Thank you for addressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused.
Good. Thank you.
No, it's a plea deadline date.
Thank you, Your Honor.
All right, thank you. Have a good one. All right, Roxanne Hernandez.
Hutchinson.
I'm sorry, Hutchinson.
I believe you have Adam Keith, Judge.
I go with what I have. That's why when people are sitting and they're staring at me, I'm like, why are they staring at me? I'm like, I don't have anything. All right, court is calling 2024 CR 007949 State versus Roxanne Hutchinson. Can I have parties announce?
Megan Galloway for the state. For the defense.
And are you Roxanne Hutchinson?
Yes, ma'am.
All right, did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am, I did.
Are you the same Roxanne Hutchinson who was placed on community supervision in 2024 CR 007949 for the offense of unlawfully carrying a weapon with a felony conviction for 7 years on November 7th, 2024? Is that you?
Yes, ma'am.
All right, state.
Yes, Judge. Are proceeding with violation of condition number 1 on or about the 19th day of February 2025 in Bexar County, Texas. The defendant Roxanne Hutchison committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True. The state will waive and abandon the remaining violations, Your Honor.
Any objections?
No objections, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, grant the motion and sentence you up to 10 years in the prison?
Yes, ma'am.
and up to a $2,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to proceed with your violation of condition number 1 in your plea of true?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and it would involve the following case, which there's plea paperwork before the court for the same defendant.
Yes.
The state probation and believe defense's recommendation is to continue probationer on this probation in cause number 2024 CR 007949, but to amend conditions to now include state ISF cognitive track followed by ISP. And probation did make a note upon disposition of pending cases, the plea paperwork on cause number. Well, I see at 2025 AL 002862, there's a cause number I don't see right now, but those conditions would also reflect and run concurrent with this cause number.
All right, what has she done on probation?
The only thing that Ms. Hutchison has done on probation has been to provide her DNA sample as required.
She was recording, sorry.
She was reporting, she reported last May 7th of 2025.
She had been reporting previous to that as well.
Right, I'm saying her last reporting is on that day.
All right, so here's my question. Has she done her parenting classes? All right. Did she obtain employment?
Judge, if I may
Yes.
inform the court, she was doing the parenting classes through CPS. She has a CPS plan because she's trying to get her child back through CPS. So she's doing the CPS classes through CPS. She has a CPS plan. So she's going through CPS. So she has a CPS plan. So she's doing her parenting classes through CPS.
All right, so how long has the CPS case been open? Was it open before this case?
Yes, ma'am.
So I don't understand why the court has received the new number 1. She knows she has a CPS case, but she's picking up a new charge and she's not following through with the conditions of the court. I don't understand why I should follow the agreement to continue her.
Judge, I think she wants to
All right.
address the court.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Roxanne Hutchison.
All right, why is the only tangent thing that I see from you is that you're picking up a new charge?
Hey, I know it doesn't reflect in the probation report or whatever, but since then I've kicked heroin. I've been sober for 9 months. I do admit that the issue wasn't me just getting sober. I got sober, but I was still doing the same things that an addict does. I was hanging around the same people. I didn't change my surroundings or my friends. So I continued to do the same things. I'm just asking for a chance to get treatment and not go to prison. I do have a 4-year-old son that I'm fighting for.
All right, so here's the thing. I don't understand why people don't think of their children before they pick up new offenses. I'm not following the agreement that you all have reached on this motion to revoke. I'm going to grant the motion revoke. Does anybody want to speak to time? She's looking at a maximum of 10 years.
Judge, we need to confirm.
All right, sure. Just have a seat. You know, sometimes it's never, my mom always says it's never the job. Sometimes it's people. And normally they're making it difficult with that ordering of things. All right, we're back on work. I mean, we're back on the record in 2024 CR 007949, State versus Roxanne Hutchinson. All right, yes.
Judge, I'm gonna re-urge the court to consider following the recommendation from probation and what the state originally wanted. Ms. Hutchinson is before the court. She verbalized that she needs help. She's asking the court for help. It's not often that a defendant is before the court and they are asking the court for some help. She is asking for help also with CPS so that she can get help from CPS. It's well known that addicts relapse. That's not uncommon. And that's what happened with her. And because that happened, she picked up other offenses. The state of Texas is willing to give her an opportunity. So I'm re-urging the court to give her that opportunity. She's not asking for you to release her. She's asking you to send her to inpatient treatment so that she can get some help. That's what she's asking. And so I'm re-urging the court to consider that.
All right. The court, as previously stated, is finding violation condition number 1 true, and the court is going to grant the motion to revoke. Does anyone wish to speak to time?
I believe that we will be going open on that. The state understands defendant is facing up to 10 on this MTR. The other case that will be before the court shortly had thoughts. Basically, the state is thinking, we pled true to number 1, you're facing 5 or facing 10, state would ask for around 5, Your Honor.
All right.
Judge, we're asking the court to sentence Ms. Hutchinson to 2 years in TDC.
All right. This is what the court is going to do. The court will sentence you to 4 years in the prison. The court will request the therapeutic community. The court will give you a credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, please.
All right, so you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do y'all want to reconsider the plea bargain agreement with the theft case?
Yes. Yes, Your Honor.
All right.
I will get this done quickly, Your Honor.
All right, thank you. All right, are y'all ready on Gregory Perneda? Court is calling 2025 CR 002023, State versus Gregory Perneda. Can I have parties announce?
Duffy Pitlock for the state of Texas, Your Honor.
Nick Aguilar on behalf of the Honorable Gregory Perneda.
And are you Gregory Perneda?
Yes, ma'am.
All right. You are here, you were placed on probation. My understanding from both parties, you're asking the court to reconsider his sentence of probation?
Yes, Your Honor.
All right, is there any objection to the court reconsidering the legal sentence that the court placed on Mr. Perneda?
No objection from the state, Your Honor.
All right, is there an amended plea bargain agreement?
Yes, Your Honor.
All right, and Mr. Perneda, did you have a chance to review the amended plea bargain agreement with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
According to that plea bargain agreement, the state is waiving and abandoning the repeat enhancement paragraph. They're asking that your punishment be assessed at 2 years in the prison. There are no applications, and there's to be restitution of $60 to the Bexar County Crime Lab for testing. Did you understand that to be the new plea bargain agreement?
Yes, Your Honor.
Defense and state, are you all both understanding that as the plea bargain agreement?
Yes, and the state did fail to write amended on top of that.
Thank you.
We may at this time.
Yes, thank you.
And we concur on that plea bargain, Judge.
And did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir. Thank you.
The previous stipulations that were entered into, are those being reoffered as well?
The state would, yes, Judge.
And we have no objection, Your Honor.
All right. So, Mr. Pernada, you were given probation, but it's the court's understanding that you were revoked, yes. So therefore, that is the reason why you're asking me to be revoked from, not really revoked, but you're asking that this new plea bargain agreement be entered on your behalf?
Yes, ma'am.
All right. And so the previous probation, you were sentenced to 2 years, suspended for 3 years. So the 2 years is within the plea bargain agreement as far as your liability with time. Do you understand?
Yes.
All right. Are you ready to proceed with sentencing?
Yes, Your Honor.
All right, then the court is going to sentence you to 2 years in the prison. There's to be restitution to the Bexar County Crime Lab of $60 for drug testing, and the court will give you credit for any time served. Is there anything else with regards to sentencing?
Nothing from the state, Your Honor.
Nothing from the defense, unless they can just tell us, somebody can tell us how many days he has back.
The clerk will be able to do that. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, and I'll request the therapeutic community. Good luck to you, sir.
Thank you, Judge.
Thank you.
May we be excused?
Yes. Bridget, are you ready?
Yes.
We'll pause for a moment.
Wow.
And I did.
Oh,
Thank you, Judge.
you're welcome. Yes. All right, thank you. And have you all changed the plea bargain agreement?
Yes.
All right, Ms. Hutchinson, if you'll come up. All right, the court is calling 2025 CR 00515 State versus Roxanne Hutchinson. Can I have the parties announced for the record, please?
Duffy Pitlock for the state of Texas, Your Honor.
Richard Gossett for defense.
And are you Ms. Hutchinson?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Are there applications in this case?
No, Your Honor.
Ms. Hutchinson, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, we are.
Ms. Hutchinson, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft of property less than $2,500 with 2 or more previous convictions as state jail felony?
Yes, ma'am.
Just one moment. Are you all waiving?
No, Your Honor, we are proceeding with the repeater to make this a third-degree punishment range.
All right, thank you.
Yes, Judge.
If you all could write the repeater on here, please. All right, do you understand if the state approves of the repeater enhancement paragraph, then this will be a third-degree felony. The range of punishment will be anywhere from 2 to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has,
Do you believe she has a rational as well as a factual understanding of the charges against her?
yes,
Do you believe she's currently competent and was legally sane at the time of the offense?
yes.
Ms. Hutchinson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1. And is she going to agree that she's been previously convicted for purposes of enhancement?
Once we get to the stipulations,
If y'all would check the box. You further agree that you've been previously convicted of 1 or more felonies for purposes of enhancement. Your punishment is to be assessed at 4 years in the prison.
we are initialing this right now, Judge.
Thank you.
Our new initials will reflect that we.
All right, thank you. This will run concurrent with 2024 CR 07949. They were taking consideration 2025 CR 07240, 2025 PF 26020. There's to be restitution of $60 and to the Bexar County Crime Lab in 2025 PF 26020. There's to be no contact with the complaining witness. Did you understand that to be your new plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Judge.
And based upon the plea bargain agreement that you all reached, the court has drawn a line through certain things. If you all could initiate those, please.
Certainly, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Because this plea, did you understand by waiving that, you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then this is charged. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objections, Your Honor.
And I'm sorry, to the enhancement, how do you plead? True or not true?
True.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
And I'm sorry, and also the court will find the enhancement true based upon your plea of true and based upon State's Exhibits 1 and attachments. Anything you wish to say on behalf of your client?
Judge, we're asking the court to follow the recommendation of the ADA and run it concurrent with the motion to revoke.
All right, the court will sentence you to 4 years in the prison, give you credit for any time served. This is to run concurrently with 2024 CR 007949. State will take in consideration 2025 CR 007240, 2025 PF 26020, 2025 PF 26020. Restitution to Bexar County Lab and the cause number 2025 PF 26020. And the court will recommend the therapeutic community. Is there anything else with regards to sentencing?
May the state just confirm that it was 2 cases that were TIC?
Yes, it was 2025 CR 007240 and 2025 PF 2602. I'm sorry, 26020.
If the state may tender to the court.
Yes. Thank you, Judge. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Yes.
And who is your other client, Bridget?
Adam Keith. But I think Ashley's is gone.
Well, I don't even, let me see if they've given me that file. Ah, she did give it to, yeah, she gave it to me. See, I'm sitting here, I'm waiting for files. All right, it's a beautiful day. Adam Keith. Counsel, where are you on discovery with this case?
Judge, we are missing EMS records. And I supplied the state with a USB. And I'm still missing 6 videos.
Plus 6 videos missing. And do you know if they have this in their possession?
Yes, they do. I gave them a USB, but it wasn't large enough.
Okay.
And then I went ahead and I downloaded it. And so I narrowed it down to make it easier. And now I'm just missing 6 videos. And I think the USB that they have should be large enough for them to upload it to that.
All right, Ms. Ferguson, can I have a 30-day reset for discovery? This will be the final reset for discovery. If there's an issue, then witnesses will need to be subpoenaed by the state.
August 18th?
All right, August 18th.
I'm out that week.
All right.
I can do the 15th, the 14th, I'm sorry, or the week after that. Okay.
All right, we'll see you back on August 14th. All right, good luck to you.
Thank you.
You're welcome. Jerry McGee. Don't hand me any more files, please. Is this for a motion to revoke?
It is just, yes, some unindicted cases. I think the state wants to see if we can reach a reset so I can get a global health on all the pending cases that we have.
All right, and state, how long will that take?
Judge, if I can have 3 weeks, it is a total of 7 cases that I have to go through. That some of them I was looking through right now, and some of them do have evidence, but on other ones, I'm gonna have to reach out and then I'll confer with Mr. Witter to resolve all cases.
All right, Ms. Ferguson, on McGee, I need a 3-week reset. All right, we'll be back on August 7th, sir. All right, thank you. Xavier Doxy.
Have a seat, sir.
And after Doxy, it will be Joshua Alcaraz, Matthew Luis Martinez, and then Ruth Gonzalez Payne. Those are the only files I have. Deputy Laura is looking at me with frowns. All right, court is calling 2019 CR 9540 State versus Xavier Dante Doxy. Could I have parties announced?
Megan Galloway for the state.
Catherine Valenzuela for the defense.
And are you Mr. Doxy?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Xavier Dante Doxy who was placed on deferred adjudication in 2019 CR 9540 for the offense of arson intention to damage habitation or place of worship on December 13th, 2019 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 43 on or about the 14th day of May 2025 in Travis County, Texas. The defendant Xavier Dante Doxy did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan in that the defendant was unsuccessfully discharged from a residential outpatient treatment program in violation of condition number 43.
All right, let's go out the record for. Over the glass jar. All right, so to that violation, how do you plead? True or not true?
True.
And that is the only violation?
It is, Your Honor.
Okay. Did you understand by pleading true to violation of condition 43, the court could find it true, grant the motion, and sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 43?
Yes.
Court will find violation of condition number 43 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking for revocation and 8 years in the prison. This is the defendant's 5th MTR, and he's just failed to comply with his conditions of probation, and so that's why we're asking for what we are asking.
Why isn't he complying with conditions?
Here, for the court's clarification, that one of the recommendations for probation on that form was that he be placed in state ISF with the cognitive tracks. Yes, it's the fifth NPR. He has successfully completed all of the programs that have been inpatient. He's gone to ISF, he's gone to SAC.
So why didn't he successfully complete this?
I believe, Your Honor, and this is just preliminary, what I believe is that one, Mr. Doxey has not been evaluated for the mental health component when he was younger. He did have issues with ADHD. He did have issues in completing tasks. When we talked about it immediately, he said he knows he needs help. He knows that aftercare is the issue for him. He's very good at completing what we ask him to in a program, but it's the aftercare that's the problem. And so it's making better decisions, and that's why we're asking for the cognitive track.
All right, so here's the issue. I think everybody knew that there were mental health issues if you're trying to burn down a church. So that's a given. Everybody knew that there were some mental health issues. So that is why I had him evaluated for MIG-BIOF at the very beginning. This is his 5th MTR. There is nothing else the court feels that the court can do for him. It's his 5th MTR. And I understand probation's recommendation, but probation's recommendation for some people who've been missing for 4 years is continue. It's like, where's this person been?
Right.
So their recommendation, I do take it with a grain of salt, but I do internalize what they're recommending. But it's his 5th motion to revoke. There's nothing else. I don't think he's appropriate for probation.
And we understand that would be difficult, and we talked about possibly working with the state and coming up with a number that would justify. I mean, he has roughly done 3 years in the course of treatment in inpatient and in jail, waiting to go to inpatient. And inpatient is not like, a walk in the park or a vacation. And I think he would like to address why he would like to stay on probation and what he feels like he would get out of probation and what he could do if you would wish to hear that.
I mean, if he wants to present a testimony to the court, I'm always open-minded. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Xavier Dante Dotson.
All right. Do you just want to give a statement, or do you want to do question and answer, counsel?
I think he can give a statement where he discusses. Go
right.
Basically, Your Honor, I feel like the leniency that's been shown from the court is very much appreciated. And I understand my flaws. I'm capable of understanding where I was wrong and where from another perspective, it doesn't look that good, but I know where I need help. I know where my strengths lie as well as my flaws. And I do believe what with the cognitive track and the opportunity to set myself on a better path would be implemented. And I think that more structure is the key here for me, if I do say so myself.
All right, so let me just tell you this. I'm internalizing what you're saying. Here's the issue. I know that sometimes people do great when they have somebody in their life to tell them everything to do every day from the time you wake up and from the time you go to bed, right?
True.
But I don't have the manpower or the hours to do that. I don't have anybody from this court who can call you for the rest of your life to make you do certain things. So you had the first motion to revoke. You were continued. Second motion to revoke. You were continued. Third motion to revoke. You were continued. Fourth motion to revoke. You were continued. And now we are here on the fifth motion. There's just nothing left for the court to do. And each time that a motion to revoke was filed, each time whatever issue you were having, conditions were set to help you address that. Your attorney is saying that you need ISF. That would help you, the ISF cognitive. But you've already been given the MRT because the last attorney you were here with said the same thing, and the court addressed that with the programs and tools that I had to address that. And the MRT was to address that. So I just don't think you're a good candidate for probation. I wish there were more programs available where there could be a case manager automatically, somebody to check in on you at least once every 2 weeks or once a month, but I just don't have the manpower for that. So I don't believe that you're appropriate, but I will tell you this. I do appreciate your giving me some insight into you.
Yes, ma'am.
And that you understand where you've gone wrong.
Yes.
So his states you were requesting 5 years?
It's requesting 8 years.
All right, so you're requesting 8 years. So probation, there any new cases or no?
Judge, I do not see any cases.
All right, the court is going to take into consideration everything that your client has with the mental health issues, the fact that we really don't have the programs or tools equipped to handle his issues. So I'm taking all of that in consideration when I give him his sentence. So I'm going to sentence him to 6 years in the prison, give him credit for any time served. There's to be no contact with Danielle Yorks, Yorks. And I request the therapeutic community. All right, did you review? Just one moment, I am so sorry. Let me find out. The court is going to find you guilty and revoke. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, here's the thing. When you're released from custody, if you can't find a place to help you with your mental health issue, if I'm here, you can come back and address that with me.
Yes,
But I would stress to you that when you're released, the first thing you should do is go to Center for Healthcare Services, okay?
Yes, ma'am.
All right, good luck to you.
Yes, ma'am.
Thank you.
And just for clarification, the credit would also include inpatient programs that he could successfully.
Yes, I'll give him
completed?
credit for any successful inpatient treatment.
Thank you, Your Honor. We appreciate your consideration.
Thank you. Matthew Luis Martinez. All right. State, where are you on discovery?
My knowledge, everything's been disclosed, Your Honor.
Were you able to tender an offer?
I have, yes, Your Honor.
Sir, how old are you?
36.
All right, Ms. Ferguson, I need a 3-week reset for a plea deadline date, please. All right, once you sign, just have a seat. Once you sign the reset form, you'll be excused.
Thank you.
You're welcome. Who's here? Ruth Payne.
Present, Your Honor.
Hello.
Morning, Judge. How are you?
Oh, it's been a
Good
day.
afternoon.
Yeah, good afternoon.
Good evening.
All right, the court is calling 2025 CR 004178 State versus Ruth Gonzalez Payne. Could I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Chris Arce for the defense, Your Honor.
And are you Miss Payne?
Yes, I am.
All right. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Payne, did you review the application for community supervision with your attorney?
Yes,
All right, are you applying for deferred adjudication or community supervision?
Deferred education, Judge.
Did you review, because both are signed, that's okay. Did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Payne, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
yes, Your Honor.
Did you understand you're charged with possession of a controlled substance penalty group 2 less than 1 gram as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and sentences you to more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call on the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Payne, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no.
Are you satisfied with the way you've been represented?
Yes, Your Honor, I have.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes,
According to the plea, there's a $1,000 fine. State recommends deferred adjudication. Did you understand that to be the plea?
yes, Your Honor.
Defense?
Yes, Your Honor. I did want to ask for the court's consideration on the $1,000 fine.
Okay. All right, state.
That is the agreement.
All right, did you review the waiver of appeal paragraph? Did you understand it? Sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes,
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 120 hours of community service restitution, and no driving without a valid license. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states exhibit 1 in all attachments at this time, Your Honor.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. Also, may I have an opportunity to
Yes.
speak on Ms. Payne's behalf? She's 58 years old, Your Honor. She's fully employed. She takes care of her elderly husband, who is 75 years old, who is a Vietnam veteran, who is legally blind from a stroke that he suffered. I wanted to discuss the possibility of early termination of probation, as we intend on getting all the requirements done within the next 6 to 12 months. Further, Your Honor, the $1,000 fine, as she is a sole provider, she's fully employed, but they're basically just relying on her paycheck. We're asking for that to be waived as well, Judge.
All right. So what is your employment?
I work for Brent Lawyer Insurance.
All right. And do you have any minors in your home?
No, ma'am, I don't.
So why are you doing this? This offense?
I don't know, ma'am, I can't.
I mean, well, what caused you to do it? And let me just tell you, the reason why I ask some of these questions is because you need to figure out why you are doing what you do so that you won't repeat it and that you can get clean and sober.
I have not smoked. I am clean at the moment.
Okay.
And I will be for the future. I will not smoke again.
May I speak on her behalf, Your Honor?
So what caused you to do this? What was going on?
I have always smoked.
What, this?
No, not that.
So why did you smoke this?
Actually, that did not belong to me. I had it in my purse and I forgot that it was there. I smoke marijuana. I do not vape though.
Okay. Does she have any prior history?
I can check on that.
Nothing other than a DWLI, Judge.
And how old are you?
I'm 58.
Okay. Do you have any criminal history other than this?
The state can confirm this.
Okay.
This is true.
Let's go off the record for a moment.
Don't even start.
And counsel, this is just something that I wonder, because if she doesn't have any criminal history, maybe this is not for her, maybe PTD.
I agree.
Okay. Counsel, if you all want more time to discuss it, we can come back at 2. Well, you can see.
It'll just be a couple moments.
Okay, no problem.
Yeah, is this on the record or?
Oh, no, we're not. Here's the thing.
Oh, are you gonna take a break or, sorry, I didn't know.
Oh, no. All right, so this is what I will do. We're gonna go back on the record. The court is not, any objection to the court not sentencing the defendant today?
No objection from the state, Your Honor.
And you're waiving PSI and TAP?
Yes, sir.
All right, so as previously stated, the court is going to find there's sufficient evidence to find you guilty. The court will defer finding of guilt. When do you think your client will have items done to present to the state?
I would say 3 months, 4 months max. We've already been on it. It's just a matter of dealing with these smaller counties that these tickets are on.
I'm going to tell
You
you.
get paperwork from them within the next 30 to 60 days.
All right, so I'm going to give you a 2-month reset. After that, she's going to be sentenced.
Understood.
All right, Ms. Ferguson, if I could have a 2-month reset for sentencing. All right, September 15th, once you sign the reset form, you are excused.
Thank you, Your Honor.
You're
May we
welcome.
be excused.
You're welcome.
Thank you, Judge.
You're welcome. We'll get someone out here in a moment, but. Yes. So I know we're back here on discovery. Do you have all discovery? Thank you,
No,
Rick.
Judge, because the state informed me that they talked to the complainant previously this week or last week. They're gonna type up notes and things like that and get that to me. And then I'll be in a better position to answer the court about having full discovery.
All right, so far, is that the only thing?
I think that's the only thing.
Okay.
Yeah.
That shouldn't be, we should all take on close to this.
Yeah. Okay. All right, let me see.
Additionally, I want to talk out of order.
Mhm.
Mr. Rivas is on full GPS. We're going to file a motion with the court, unless the state wants to agree to change it to partial so he has the ability to work. Because right now he is confined completely to his home and the courthouse. And I'll confer with the state about that, Judge.
All right. So you're saying all he's allowed to do is go to work?
No, right now he's on full GPS. He's not allowed to work.
All right, have you tendered to the state his work schedule and where he's employed?
You're not employed right
I was fired and I got arrested.
Ah, okay. All right, so this is what we will do. Norma, I need a 3-week reset for discovery on Rivas, please.
August 7th.
All right, so we'll be back. Yes.
I'm in Travis County on 2 different clients that day. Can we do August 5th?
Doesn't Bear alphabetically come before Travis?
It does. Yeah.
All right, what date?
Tuesday, August 5th?
All right, Ms. Ferguson, if we can put that August 5th, please. All right, so you'll be back on August 5th. State, would you be prepared to tender an offer on August 5th?
I believe an offer has been tendered to Mr.
They
Bailey
have,
already.
Judge, yes.
All right, so what's going to happen, we're going to make sure that you have your attorney has all of the discovery. When we come back on August 5th, if he has all of the discovery, your next court date is going to be a plea deadline date. Is there anything else?
Not for now, Judge.
All right, once he signs the reset form, he will be excused. Thank you for dressing appropriately for court.
Thank you. Just have a seat.
Right. Miss Manning, if you'll come forward, please. All right, so what is the discovery?
Yes, Judge, there's ample discovery at this time. My client has informed me that she made calls to law enforcement complaining about the complaining witness in this case, to provide context and background for the circumstance that occurred in this situation. I'm gonna be requesting those from the state. I have an investigator with my office as well that they can make arrangements to try to get a hold of those calls, which I feel are relevant to these proceedings, Judge. So we request a one more discovery reset because we feel that can aid in her defense.
All right, and is it just for the calls or is there anything else?
Just for the calls, Judge, the calls. She also had called ACS as well to complain about how the complaining witnesses were treating their animals. We're gonna try to get those reports and calls that were made out for service.
All right, Norma, can you put this for the week of August 25th? I think that should give everybody enough time.
Yes, Your Honor.
Yes, ma'am. I can do the 25th or the 26th.
25th would be perfect.
All right, so we'll be back on August 25th for discovery. Is there anything else?
Nothing from the defense.
All right, thank you for dressing appropriately for court. Just have a seat and your attorney will bring the reset form to you. All right, Ibanez. Hello. Hi. So where are we on the discovery from Leon Valley?
So they said Leon Valley provided everything they had. They got some additional stuff from U-Haul regarding this charge. But the state informed me that they may have a case that they're looking to potentially indict, depending on the strength of the evidence, when my client was arrested on the warrant that went out for this UMV case. I believe it pertains to a fraudulent use of identifying information. So I believe the state wanted to see if they're going to proceed with that, if they're going to reject it, the strength of that. So that way, if we do some course of action on this one, that case doesn't pop up and we're back at square one, Judge. So they brought to my attention the fact that there's a case in intake at this point. So I know Ms. Galloway said that she wanted to check in on that case to see if they're going to proceed on that or potentially a global offer if they feel they have enough evidence on that.
All right, Ms. Ferguson, Mr. Ibanez, if you'll put this for discovery as well on August 25th. All right, thank you for dressing appropriately for court.
Thank you. Upon executing the reset form may be excused.
Yes. Luis Gandaria, Scandinaria.
Also present on that, Judge.
You know, I'm mispronouncing that. I'm working.
The double L's for is a Y. Yeah, you get that. You get that pretty good.
Yeah, it's hard. Okay. All right, so where are we on this case?
Yes, Judge, I know we're set for plea bargain deadline today. Discovery looks good, looks to be intact. My client did wish to reject the state's offer and is requesting a jury trial.
All right, jury trial or bench trial?
Uh, Yeah, he's requesting jury trial, Judge.
All right, Norma. I need a jury trial date, 2 days. That includes jury selection.
Yes, ma'am.
So we'll be back. That's August 18th?
Yes, ma'am.
August 18th. Now, I will tell you, there's another trial that is set before you. So that trial may go. If it doesn't go, or if it falls through, then your trial will go.
Definitely, we'll be prepared either way, Your Honor. Appreciate that.
All right, and if you all can make sure that I have an acknowledgement of discovery, please.
Yes, Your Honor.
All right, thank you. Do you have any questions about anything? All right, thank you.
Thank you.
Joshua Alcaraz.
How you doing, Ms. Boyd?
Hello, how are you doing?
I'm doing okay.
All right, is everything going fine with you?
Yes, ma'am.
All right, just give me one moment.
Okay, go ahead and take your time.
Oh, I appreciate that. The court is calling 2024 CR 01078 State versus Joshua Alcaraz. Can I have parties announced?
Dutton, for the state of Texas, Your Honor.
Danielle Cranbrook for the defense.
And are you Mr. Alcaraz?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
I believe so, yes.
Well, I want to make sure. It's this document that states that you're on deferred adjudication. Did you review that with your attorney?
Yes, ma'am.
Are you the same Joshua John Alcaraz who was placed on deferred adjudication in 2024 CR 010781 for the offense of possession of a controlled substance penalty group 1B 1 to 4 grams on November 19, 2024 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Joshua John Alcaraz. Defendant there failed to report to the supervision officer as directed for the months of April, May, and June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4. Is there a proposed agreement?
Yes, Your Honor, there is. That is to grant the state's motion to adjudicate defendant, to revoke defendant, and to sentence defendant to 3 years TDC.
Is that the agreement?
It is, Your Honor.
Are you asking the court to follow that agreement?
Well, no, honestly, ma'am, I was hoping on just a reinstatement, seeing as I've already been put on probation, and it was only 3 months that I had been, allowed to.
Okay, I understand what you're saying.
Yes, ma'am.
So I'm not gonna swear you under oath because I'm sure your attorney maybe she doesn't want you to give testimony. But this is what I want to explain to you. And I want you to internalize what I'm saying, all right? Because I understand that sometimes we want what we want, right?
Yes, ma'am.
But do you remember the date you were placed on probation?
Yes, ma'am.
November?
Yes, ma'am, I do. I remember speaking with you and everything. But
Yeah.
as well.
So it was November 19th, 2024.
Yes, ma'am.
Now, I am the one who placed you on probation,
Yes, ma'am.
all right? So tell me, what have you done since you've been on probation?
Since I've been on probation, I know I haven't been reporting. You wanted me to get my GED. I have made arrangements with SA leadership.
But no, here's the thing. Number one, which is free, the easiest thing you can do is report to probation.
Yes, ma'am.
You didn't do it.
Yes, I have been slacking on that. I do understand that. But like I said, about the other arrangements, I have a job opportunities out the way for me. I've remade connections with my mother. I have solid living space right now. And again, I have made arrangements with SA leadership. I've been working through, Job Corps, through SA Job Corps, day to day. So it's not like I've been wasting time. The reason I haven't been reporting to my probation officer is because, I don't really have a solid reason for that. That's the one thing that I've been slacking on.
So let me ask you this. And I want you to think about it. Don't even think about it as though I'm talking about you.
Mhm.
Just think about persons in general.
Okay.
All right. So let's say Stephanie Boyd is placed on probation.
Yes, ma'am.
All right.
Yes, ma'am.
And I say, okay, I'll agree with you. I'll be on probation. Don't send me to prison. Place me on probation.
Mhm.
So I enter into a contract to be placed on probation. And they say, well, wait a minute. There are going to be conditions with that. You're just not placed on probation. You can do whatever you want to do. You have to report.
Mhm.
And then I don't report. And I just continue on as though I'm not on probation. I know that sometimes people wish that their probation was like a municipal court. You know, in municipal court, sometimes you plead to a ticket and they say, just don't get in trouble or pick up any more tickets for 2 years and it'll be off your record or whatever. Criminal court is completely different. There's none of this. Just don't get any trouble and you're free to not report or do whatever you want to do.
Mhm.
That's not the way it works here.
Yes, ma'am.
And what I will tell you, the easiest thing to do on probation is to report and not pick up new cases. And you didn't report. This whole thing that you're telling me what you've been doing,
Mhm.
I don't know. Probation doesn't know. You know why?
Because I haven't been
You
reporting.
haven't reported. And I will tell you, your attorney has worked out a nice agreement for you
Yes, ma'am.
because you know that you truly deserve more than the 3 years, right?
Honestly, I wouldn't say that I do deserve more, but
Mhm.
the agreement is worked out in my favor.
That's what I'm saying.
Yes,
So she's done a great job for you.
yes, ma'am.
Have you ever read that book? I finally read it because
Mhm.
I have a niece, right?
Yes, ma'am.
I would always see it when I would go in the bookstore and it would say, give a mouse a cookie.
Yeah.
And I was like, hey, what is this about? So I got it. I'm like, oh, you give a mouse a cookie. You know what that mouse is going to want?
He's always gonna want more.
A glass of milk.
Yes, ma'am.
Then I want a place to stay. Then I want this.
That's
So
funny.
she has, you're not a mouse, but she's given you 3 years and now you want more.
Yes, ma'am.
And you're not deserving of more, right?
If that's the judgment that you're making, ma'am, then I guess I can't do anything but agree with you.
No, you don't have to agree with me. Sometimes people are like, oh, I'm not in agreement,
Yes, ma'am.
right?
Yes, ma'am.
But she's worked out this agreement for 3 years. Do you want me to follow it?
I think it would be for the best, yeah.
Are you waiving your right to appeal?
Yes, ma'am.
All right. Then the court is going to find violation of condition number 4 true. The court will find you guilty, revoke, sentence you to 3 years in the prison, give you credit for any time served. The court will recommend the therapeutic community. Therapeutic community doesn't increase the time that you're in custody, but it's designed to help you maintain your sobriety when you're released.
I just wanted to make sure, since I've been hearing, there's a lot of hearsay about it.
Oh, I love the hearsay.
Yeah,
Okay.
I could go without it, being here, but I was getting 2 for 1 days.
All right, so here's the thing about that.
Would you be able to honor those for me?
No, and let me just tell you why. I'm not in charge of your receiving 2 for 1 or 3 for 1. The person who's in charge of that is the sheriff. The only thing that I can do is I've sentenced you to 3 years. And what I can say is you are not supposed to do more than 3 years.
Okay.
Now, I know just for being at the jail, you get 2 for 1 if you don't get into any trouble.
So should that follow me over there?
It should,
Okay.
but I'm not in charge of that. If the sheriff wants to take away your 2 for 1,
Yes, ma'am.
they can take it away.
Okay.
If they want to take away your 3 for 1, they can take it away.
Yes, ma'am, I understand.
And if you were a trustee status and doing work over there, you would have 3 for 1. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Get your life together. Do it for your family.
Yes, ma'am.
And if when you're released, if you can't find a place to help you with your sobriety, if I'm still here on the bench, you can come back here. I'll pick up the phone and call a place for you, okay?
Thank you, ma'am. Thank you very
Right.
much.
You're welcome. Good luck to you.
Thank you,
You should thank your attorney. She did a great job for you.
Have a seat.
If I could be excused.
Yes,
Yeah, they're gonna.
you too.
No, which one is cute?
What?
Stone soup.
Oh, I love stone soup. We had to read that in, I read that in elementary. Yeah. Hello, Mr. Bond.
Judge, afternoon.
Oh, yeah. All right, so we're here for discovery. Is there still outstanding discovery?
Not that I'm aware of. We signed and submitted discovery agreements on both cases.
Oh, he has, more than one case with us?
He has two cases, yes, Judge.
All right,
2025, 5133 and 5132.
okay.
But I'm aware
And
of-
has an offer been tendered?
Yes,
All right, sir, how old are you?
I'm 34.
All right. And Mr. Bonk, I know you have vacations and everything
Yes.
on file, so when are you available to come back for a plea deadline date?
What time frame are you looking at, Judge?
I was looking at August, but I think you're out in August, correct?
I'm here in the middle of August. I'll be with you on the 18th.
You want to just put it on the 18th?
Sure.
All right, Norma,
Yes, ma'am.
on Mr. Richard Thomas, plea deadline date, August 18th. All right, so you're gonna come back on that date. On that date, you need to let the court know whether you've reached an agreement with the state. If you have not reached an agreement, your next date will be a jury trial or a bench trial. Do you understand?
Yes, ma'am.
All right, you have any questions about anything?
No.
All right, thank you.
Thank you.
Deputy Laura, we're finished with Mr. Thomas. Lawrence Cloud. Hello.
Good morning, Judge.
Good morning.
Afternoon again. I
Good
did it
afternoon.
twice.
Yes,
Morning, afternoon.
good afternoon. Yes.
So Mr. Cloud and I are recently acquainted.
Mhm.
I'm still getting all the discovery from the state, and Mr. Cloud and I would like to chance to review all that together before we go to the next step if possible.
All right. So, Ms. Ferguson,
Yes, ma'am.
on how much time do you need for discovery? What are you thinking?
Probably maybe the same day we just chose.
All right, Norm, if you can bring this back on August 18th for discovery, please.
Yes, ma'am. Will do.
All right,
Thank you, Judge.
thank you.
Yes. I'll be in touch.
David Alfonso Saldivar Salazar. All right. Hello.
Hello, Your Honor.
All right, you're on this side, counsel.
Yes, ma'am.
All right, so he has a motion to revoke and a new case.
Yes, Your Honor.
Has the motion to revoke been heard?
No, Your Honor.
Okay. All right, so what is happening with this new case?
New case.
Have you conferred with the criminal trial division on the new case?
We have not heard with the CTD on the new case, Your Honor, quite yet. I. No.
All right, you all need to, that's okay.
Yes, ma'am.
All right. They're not ready on this one. Yes.
I think this all revolves around the four family violence ones that I kind of took the lead on. And an offer was tendered that included a case here with CTD
Oh.
case, so I think that might resolve that particular.
Okay, all right, thank you. I tell you what, I'll give you a chance to
ma'am.
step back and confer, and start, take a seat in the box, please. State versus Rick Anthony Contreras. Can I have parties announced?
Rick Pena for the state of Texas.
David Andre Woodard for Mr. Contreras.
And are you Rick Anthony Contreras?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rick Anthony Contreras who was placed on deferred adjudication in 2021 CR 1287 on August 29, 2022 for a period of 5 years for the offense of injury to the elderly bodily injury? Is that you?
Yes.
All right, state.
I guess Your Honor, we're here this afternoon on the state's motion to enter adjudication of guilt in the community supervision. Violation condition number 14. On about the 13th day of July, 2023, in Bear County, Texas, the defendant, Rick Anthony Contreras, who then and there failed to apply for, provide documentation of attendance, and comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following program: hostility management aggression course and violation of condition number 14.
How do you plead to that? True or not true?
It's true.
State the waive the remaining violations, Your Honor.
Any objections?
No objections, Judge.
Did you understand by pleading true to violation of condition number 14, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition 14?
Yes, it's just that my son had passed away on June.
No. So here's the thing. I'm just asking you that specific question. Do you understand?
Yes.
And then if you have reasons that you want to express to the court for why you did certain things or didn't do certain things, that would be part of your mitigation, and your attorney can ask questions if he chooses. You understand? No problem. So the court will find violation of condition number 14 true. Is there a proposed agreement?
Yes, there is, Your Honor. That is to deny the motion, alter and amend conditions to allow for SATIF, followed by aftercare.
Is that the agreement, counsel?
It is, Judge.
All right. Is there something you wanted to say to me?
No, it's just that,
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Rick Anthony Contreras.
All right, what did you want to say to me?
It's just that I had lost my son to a tragic death and accident, and I went through depression, and that's the reason why I stopped reporting. And like 4 months passed by, and when I finally started coming to, I realized that I failed to report it, and I just got scared and just stopped reporting after that.
So what is this about drug use?
Excuse me?
Drug use, let's talk about that because they're recommending SATA.
Yeah, well, I'm not gonna deny I did have a good problem with drugs, but
So what were you using in this time when probation had not seen you?
marijuana.
No, but nobody is missing probation on just marijuana.
Mhm.
So here's the thing. Your attorney has worked on an agreement with the state.
Mhm.
I don't have to follow it. I can sentence you to 10 years in the prison. So it's probably in your best interest for you to be honest with me, because I'm seriously considering following your agreement. They're saying that
Yes.
they agree that you go to SATA, but let me just tell you, I'm not sending someone to SATA on the first try just because they use marijuana. So I know there's more than this. So here's the thing. You need to be honest with me. If you don't want to be honest with me, then I will understand. You understand?
Yes, ma'am.
All right, so we're going to start over. And we'll just start from ground zero.
Mhm.
So state your name for the record. You're under oath.
Rick Anthony Contreras.
All right, so state and the defense have agreed that you should go to SATA. Why are they asking that you go to SATA?
Because I haven't used drugs,
All right, what drugs?
meth and marijuana.
Anything else?
I don't think I can use anything else. I just
All
haven't
right,
used it.
so how often had you been using meth?
I wasn't using it that much. I used it a few times, but
I don't know what that means because I wasn't with you.
maybe once a week or twice a week.
All right, that's a lot. In my world, I think that's a lot.
Yes, ma'am.
So are you employed?
Yes.
Doing what?
I work a groundskeeper for a gentleman in Bernie, Texas.
For a gentleman in Bernie,
Yes,
Texas?
he's the owner of a concrete foundation company.
Mm-hmm. And so what exactly are you doing for them?
I do all the landscaping work for him and plant the trees and keep the garden like a basic gardener.
What trees are you planting?
Trees that he buys for his property.
But what would be the name of these trees?
I plant like some. Planted some, can't even think of them, but I planted like 20 different trees there that he bought for the first property that I planted there and some, can't even think right now, just like my shop, but I planted several trees for him there. I did all the landscaping there, the landscaping design.
And are you digging the holes to put the plants in?
No, we use an excavator.
And do you start the trees off with fertilizer?
Well, I dig a hole and then I put fertilizer in the ground, I put some root stabilizer in. And then I water it, and then fill the hole, put the tree in there and fill up the hole with the dirt.
And you're only using the fertilizer for planting of trees and nothing else?
Well, for some plants,
I mean, and just plants and trees, nothing else?
yeah, just that's it, basically, for the plants and trees that we got there.
All right. And do you have any children in the household?
No, ma'am.
All right, the court will deny the motion. Alter and amend conditions to include a referral to safety. I'm sorry, not safety, SATA. And that's to be in custody. And followed by aftercare. And there's to be no residing with minors. Probation, is there anything else? Okay. Is there anything else you need from the court in order to be successful?
I think it's,
All right. All right, we can go off the record. Here's the thing, you need to be honest, at least with me in this court, because I'm trying to put conditions so that you can be successful and I don't have to see you anymore for violating your conditions, okay? If there's something you need, if you feel as though you're gonna use, pick up the phone, call your probation officer. So what they're gonna do is they're gonna let me know about it and we're gonna see if we can get you some help, okay?
Thanks.
All right, you're welcome. Good luck to you.
Thank you.
Thanks, Judge.
My Rose of Sharon hasn't been the same since the freeze.
Thank you so much.
So, all right, good luck to you. Who's here on Joshua Gonzalez?
Present, Your Honor.
Seems like it's a never ending day today.
Yeah, it does. Almost there. Judge, I believe this is my first or second appearance here.
Mhm. For this one, let me see. I think it's the first. So we'll need a reset for discovery unless you know that you have all the discovery.
I definitely do not have all the discovery, Judge.
Okay, do you have any idea what is outstanding?
No, I do not, Judge. I need to look at body cams that I assume exist, but I don't know if I haven't looked in discovery to see if they're there.
All right, so what we'll do is we'll recall this in 30 days for discovery. Ms. Ferguson, what date, please?
August 19th. August 19th.
All right, August 19th. All right, we'll bring you back on August 19th. Do you have any questions? All right, thank you.
Thank you, Judge.
You're welcome. All right, Mr. David Alfonso Salazar. So where are we?
Same place, Your Honor. We've conferred. I believe that we have all the evidence from the state on the new case.
Okay.
We don't have an agreement at this time, Your Honor.
All right, Ms. Ferguson. I need a contested MTR date on 2020 CR 4184. All right, state, will you be ready for a contested hearing on July 28th?
I think I should.
All right, thank you.
Anything further, Your Honor?
No, that's all. Do you have any questions, sir? All right, thank you.
Thank you very much, Your Honor.
Have a seat, sir.
All right, who's the attorney?
That's
Sawyer. All right, if you'll come forward, sir, just give me one moment. All right, sir, we're gonna recall your case for next week. Your attorney is in another county.
Okay.
All right, Ms. Ferguson. If I can have a reset for next week. What is best for you, Monday or Tuesday?
It don't matter.
All right, either one.
I'll do the 21st for Monday.
All right, so we're gonna bring you back on July 21st. Once you sign the reset form, you're excused.
Okay, thank you.
You're welcome. Thank you for dressing appropriately for court.
Grab a pen, the file, and sign right now.
Adolfo Manuel Rodriguez Villafon. Thank you. Counsel, do you have all the discovery?
Yes, I do, Your Honor.
Was an offer tender?
No, they were gonna review some issues with the case and they were gonna tender me an offer. I was there this morning.
All right. So did they give you an idea when?
Yes, they said before the next setting.
All right. Ms. Ferguson? Set this for the fourth week in August, and it's for the state to tender an offer.
I can do August 28th.
All right. So here's the thing.
That will work, yes.
All right, thank you. Oh, he needs an interpreter.
Okay, do you want me to call him down?
Yes, please. All right, just have a seat. Sir, have a seat and we'll call you back.
Sí, ahorita te hablan.
All right,
Thank
thank you.
Thank
All right, just give us a moment. We're gonna have
No
an
problem.
interpreter come.
Yes. Yes.
There's only a few places.
All right, Troy Allen Pollock. Court is calling 2024 CR 009575. State versus Troy Allen Pollock. Can I have parties announced?
Jim Oldersdorf for Troy Allen Pollock.
And are you Mr. Pollock?
Yes.
Mr. Oldersdorf, I need your signature.
I'm sorry.
No problem. Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Pollock, did you review the application for deferred adjudication and community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
It's this document that tells you what you're charged
Yes,
with. Did you review that with your attorney?
Yes, ma'am.
Did you understand it? I'm
Yes.
sorry, did you sign it?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor. I mean, we'll waive it, yes.
State, are you proceeding on the indictment as presented?
Judge, I believe we kept, even on count one of them.
That's correct. Any objection to the waiver of count two?
No, Your Honor.
All right, did you review the court admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft of service? Less than 2,500, I'm sorry. From 2,500 to $30,000 as a state jail felony?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand the range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine? Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both questions, Your Honor.
If you have any. Yes. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1. They're recommending deferred adjudication. They're taking in consideration 2025 PF 19558. There's to be no contact with the complainant, the theft program, the MRT, the TAP evaluation, and follow recommendations. All right, for the first time, Bashan is like, yes, I can hear you.
You did get a little louder there for a while.
Right. Did you understand those to, that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 100 hours of community service restitution, and no contact with the complaining witness. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No contact.
State, any evidence?
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? The document that
Yes.
has the police reports in it?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We will do, if it will allow us to do so, respectfully request.
All right, so here's my question. Number 1, Kelly Blue Book must have gone up in their estimations of values of vehicle because a 2019 Honda, you're telling me that's worth $24,000?
No, it can't be.
I mean, that's what it says in the stipulations. It says black 2019 Honda CRV. Now, this doesn't tell me what the miles are on the car, but they say the Kelly Blue Book value, fair market value is $24,845.
Well, we were surprised because the offense date is in December, I believe, of 23.
Yeah, so I don't understand.
Maybe we should have a hearing with regard to that issue, Judge. I don't know.
Well, I think so, because was the vehicle ever recovered?
We don't know. This is.
Because it says that they never got the.
Yeah, I could not locate where they said they recovered it.
Well, it says the listed vehicle was never returned. So here's my question. Are we saying that the value of this vehicle is $24,845 for a 2019 Honda CRV? I mean, I can understand if it's $24,000 if you're taking into, they could have rented the car because this is from Avis Rental.
Judge, if I may, what we placed in the plea bargain portion of the plea bargain page in front of the court would be, I think we're looking at it being determined. Let me see if I can find that.
Oh, no, that's what it says, restitution to be determined, but
Oh, yes.
I mean, let's be honest, let's say the restitution ends up, it is $24,000. Do you have $24,000?
I'll get it. Like, I mean, it's like, it is my probation, like.
I mean, let me just tell you, everybody says that, but there are certain legal rules that are associated to people on probation with regards to payment of restitution. So you can't put anybody in prison for failure to pay restitution if they are able to prove that they are unable to pay restitution. That's the issue. So this is what we're gonna do. We're gonna reset this for restitution here, and we're gonna see if somebody's gonna come in and show me a Kelly Blue Book value of $24,000 for a Honda, 2019 Honda. Because if that's the case, some of us should open up parking lots. I don't know. All right. So, State, do you know how long it would take to determine?
Judge, if I may,
Yes.
I don't buy cars very often. Obviously, I drive older cars. But I do, because of my real estate holdings and my attempt to lower my property taxes, refer to Google quite often as opposed to just Kelly. There's several sources out there with regard to the values of properties and the taxing authorities. Yeah, you can look at quite a few sources, what I'm speaking to, as opposed to the court.
Well,
speaking.
according to, we're off the record, according to AI,
Yeah.
the value of a 2019 Honda CRV typically ranges from $14,000 to $25,000.
Judge, we'll gladly go along with that.
The 25 is the higher.
I just.
And then some of it, they say starting at 17,000.
Yeah, Judge, again, I'm the wrong person to value cars, but I can tell you for a fact, I constantly review the values of my properties with regard to taxation.
All right, so what we'll do is we'll come back, Mr. Duffy, for, yes, on, let me see, is 30 day, well, how much time do y'all need?
A sensible 30 would be nice for the state.
Okay. All right, Ms. Ferguson, can I get a 30-day reset for restitution hearing?
It would be the 18th of August.
All right, we'll be back on August 18th, so you know what the restitution is.
And I was just checking.
It don't matter to me, like, just tell me when to be here.
Okay, 18th of August it is. I was just checking. He's a gentleman on the road, apparently, from what I determined.
All right, so we'll be back on August 18th. Once you sign the reset form, you're excused. Thank you so much for dressing appropriately for court.
Okay, thank you.
Thank you.
See you. I need you.
And then we have the interpreter here. And I'm ready whenever y'all are ready.
Sit down.
We're right here.
Okay. Oh, if you could come up. All right. Mr. Villafan?
Yes.
All right, you're gonna come back to court on August 28th, 2025. On that date, the state is gonna tender an offer. And you'll need to let the court know, I'm gonna give you a separate date from that date for you to let the court know whether or not you have reached an agreement with the state. And the other thing I want to talk to you about is you were late for court. You are not allowed to be late for court again. Court is at 9 a.m. Right. So make sure that you're on time. Do you understand?
Yes.
All right, once you sign the reset form, you are excused.
Okay, so then on the 28th, I have to come back here?
Yes. at
Yeah.
9 p.m.
Okay.
And court is in the courtroom, not out in the hallway.
Okay.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court. We're gonna see. All right. The court is calling 2025 CR 0085868W. State versus Jesus Zamaripa. Can I have parties announce?
Everything of the state of Texas.
Mario Moreno for the defendant.
There should also be a second case. as well.
Yes, I just saw that. Thank you. And the court is also calling 2025 CR 001042. Are there applications in each of these cause numbers?
Yes, Your Honor.
Counsel, in each cause number, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Mrs. Zamaripa, in each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And the cause number ending in the letter W, did you review the waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you understand by signing that you're waiving the reading of the indictment?
Yes, Your Honor.
Did you understand you're waiving the right to have a grand jury hear the evidence in this case and make a decision on whether or not there's enough evidence to hold you over for trial?
Yes, Your Honor.
Did you understand that your attorney has 2 days? Well, your attorney has the passage of 2 days once the information is presented to him? Did you understand that?
Yes, Your Honor.
So you're proceeding by information today, correct?
Yes, Your Honor.
So once that information is tendered to your attorney actually has the right to have 2 whole days pass before anything is proceeded upon on this case. Did you understand?
Yes, Your Honor.
And did you understand that your attorney has the right to have 10 days to prepare for trial for this case?
Yes, Your Honor.
Did you understand by entering into a plea bargain in this case, you are giving up all of those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
The court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And the cause ending in 4-2, did you review the indictment with your attorney? Did you understand it? And did you, did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we waive.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
In the cause number ending in the W, you're charged with assault of a pregnant person. And in the cause number ending in the number 2, you're charged with evading arrest detention with a vehicle. Both of those charges are 3rd-degree felonies. The range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them, the right to remain silent. Did you understand by entering into these plea bargain agreements, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into plea bargain agreements in these cases?
Yes, Your Honor.
In each of the cause numbers, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide any defenses?
Yes, Your Honor. We have-
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do believe he does.
Just 1 second. There's on this one.
Yes, sir.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir.
Mr. Zamaripa, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, sir.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial.
Yes, sir.
In each cause number, did you review the plea bargain page? Thank you.
Yeah.
With your, did you understand it?
Yes, Your Honor.
In each cause number, according to the plea bargain agreement, punishments to be assessed at 5 years in the prison. There's a $1,500 fine in the cause number ending in W. The state is opposed to your application for community supervision or deferred adjudication. The cases will run concurrently. The state is taking in consideration 2025 CR 006532. There's to be restitution of $180 to Texas DPS for drug testing and cause number 2025 CR 006532. There's to be a judgment set on the unlawfully carrying a weapon JN 6784286. There's to be no contact with the complaining witness. State maintains the right to make recommendations if you are given probation. There's also an affirmative finding of family violence and no contact with the complainant and the case number ending in W. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, sir.
Did you understand that to be the plea bargain agreement in each of these cause numbers?
Yes, sir.
Defense?
Yes, Your Honor, with only just something for the notice for the court in regards to the no contact order that's placed there after discussion with the state. That may be something, or not maybe, that is something that we would like to discuss with the court at sentencing.
Well, then, if you are going to discuss it with me, then you're not in agreement to it.
Just to that condition, but they did say that that is something that would be left open for the court.
He brought it to my attention that this defendant's current bond conditions allow for no harmful or injurious contact.
Mhm.
However, at this point, we feel from our end that no contact would be best, but I did say that we could go open to the court on that. I did agree with them on that.
All right, so any objection then to moving that as outside of your plea bargain agreement and moving it to recommendations from the state? Then does everyone understand that to be the plea bargain agreement?
Yes, sir.
Yes, sir.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that there be no contact with the complaining witness. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then in cause number 2025 CR 001042, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2025 CR 008568W, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
With regard to both cases, Your Honor, at this time, state offers of evidence, it's exhibit 1, all attachments.
No objections, Your Honor.
And state, have you spoken with the complainant?
We have one, yes.
All right, in each cause number, did you review the waiver and stipulation of testimony with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, we can all go off the record. My understanding is it takes about 8 weeks for a PSI or TAP evaluation. So we can reset it for 8 weeks for a PSI TAP evaluation, or I can give you a shorter reset if you waive PSI and TAP, and then you can bring in whatever witnesses you want to bring in.
Just so I can understand correctly, Judge, if we do the PSI and TAP, is the judge, I mean, is the court still allowing us to have witnesses to be presented?
Oh, sure.
Oh, okay, well, we would want to do the PSI application.
All right. Is there any type of mental health issues?
Yeah.
All right, so Ms. Ferguson, I need a reset date. Probation is gonna be a PSI TAP evaluation in MIC. All right,
September 11th, Judge.
all right, September 11th. Once you sign the reset form, you will be excused. What I can tell you is you need to make sure that you make all of the appointments. Sometimes with probation, you have an appointment where you're just going in so they can meet you. And then there are separate appointments they send you to. For example, there's a different date for the TAP evaluation, a different date for the MIC evaluation. You need to make sure that you keep your calendar well and make sure you make all of those appointments. You understand?
Yes, Your Honor.
All right, thank you. Thank you for adjusting appropriately for court. Probation will speak to you.
Thank you, Judge.
You're welcome. Raphael Bernal. And Rick, if you can let me know which one that is, and they can pull the file and I'll make sure I write it on there.
Okay, I can let you know right now.
Okay. Let me grab a sticky note. If you want to write it from here,
Yes, sure.
then I'll take care of it.
Thank you, Your Honor.
You're welcome. All right, Raphael Bernal. Oh, Mr. Bernal.
No.
Hi. So you want a jury trial, is that correct?
Yeah, I was out for 8 months.
No. Here's my question. Legally, I'm not supposed to hear what plea negotiations y'all have made because legally those are supposed to be confidential. So I'm gonna wash my brain of what you just said. So my only question for you is, are you reaching an agreement with the state or do you want a jury trial? That's either yes, I want a jury trial, or no, I don't want a jury trial. All right, so here's the thing. We've been here on this train before. So the train stops here. Do you want to, if you want a jury trial, I will give you a jury trial. So do you want?
I'm a lawyer.
Well, do you have money for an attorney? All right, then that's where we are. This is your attorney.
No,
All right, so you're gonna represent yourself?
no, you can hire me another attorney.
No.
Judge, respectfully, I'm sorry, can I speak to my client for a second?
Yes.
Mr. Now, can you step over, please? Step away from me.
Working here. No. She just said, they don't send you to prison just because you don't have money. I don't have money, I need another attorney.
All right, let me.
I need another attorney.
Oh, no, just 1 second. Let me ask you this.
Yes, Judge,
Are you appointed or retained?
appointed.
All right, you're appointed. So what that means is that the government, the state of Texas, the taxpayers, because you can't afford an attorney, had this attorney appointed to represent you.
Right.
So this is your attorney. If you want
Not
another,
representing me.
if you want another attorney,
Yes.
then you need to hire one.
How?
I have no idea. All
You
right.
don't have no idea.
Judge, may I present the case?
I'm telling you
May I go
how.
forward and try to represent him? He has,
No, you
I
will
think
find
he's
me
upset.
another lawyer.
I think he's upset and it's possible that I mentioned before, he's very knowledgeable. He knows a lot of the law. It's old law. I've tried to update him on some of the laws, on some of the charges that he has had in the past and the charge we're talking about today, which is burglary of the building. I
It's a
explained the
repeat.
different. I explained the
That
difference.
time I was here before.
Mr. Bernal, can you-
No, I
So-
need to explain.
So what I
It
would
was
like
the
to do right
same
now.
thing, burglary of a building, and it was dismissed. And now it's a repeater.
Let me ask you something, Mr. Bernal.
Yes,
You're Raphael Bernal?
yeah,
What do you want to say?
I just said it.
No, what do you want to say? We're here to listen because you keep interrupting your counsel. So nobody's going to say anything. I'm going to let you speak. What is it that you want me to know?
What did you not hear?
I didn't hear any of it.
Why not? Everybody heard.
No, they did not.
You didn't hear it.
No, they said they did not. So what is it you want to hear?
Judge, can we get a second, please? I'm sorry,
No, that's okay. Sometimes, counsel, I understand where you are. But sometimes when people don't get their way, they behave childlike, which is fine.
I'm
So
not
this is what's gonna.
I'm 64 years
Counsel-
old, I'm older than you.
Counsel, you assume that. Counsel,
What do you
this
mean I assume that?
counsel, this is what's gonna end up happening. You're gonna go to jury trial. You will be his attorney. If he doesn't want to take your advice or listen to you, then he doesn't take your advice or listen to you. But people need to realize
You're
that when you're
conspiring
appointed,
against me.
people need to realize that when you're,
That's bullshit.
when you're appointed an
She's
attorney.
working against me, you're working against me, the district attorney is working against me, and you're not listening to me.
Yeah.
And everybody hears me. Hey, look, now they're gonna call me.
We're not assaulting you, just.
Yeah, you don't need to do that.
Thank you.
You're welcome. So the bottom case number is one that only shows up as being sentenced to, the top two need to be concurrent with it.
Thank you.
I'm sorry about that.
Hey, here's the thing, you know what I always say?
It's one of those days.
No, it's fine, but
Well, even for me too. My
there's a
short
song
errand
by
term.
Monica, just one of them days, but here's my whole thing. Everybody needs to stop apologizing for other people's action. That's a grown man. There's no need for you to apologize for him.
It offends us to see.
It does, yeah.
so bad.
Don't feel bad. That's not you. All right, Frank Garza. All right, so your client was recently found competent.
That's correct, Your Honor. And I wish it were just straightforward and the psychologist's report indicates that with medication, he believes he's competent. And I believe he's competent. He understands the process, understands the charge. But the report also indicates that Mr. Garza suffers from delusion and all that. And that's been the problem up until now. That's why I filed the motion originally. Factually, just not there on events and things. We thought we had something worked out, but it's not working out the way it's charged. And so I think I need to have, or possibly file a motion to have him evaluated by an MD to get a diagnosis of his issues. They reference schizophrenia and other things in there that could impact his sanity at the time of the offense. And that may be the way to go. I'm not
So
sure.
you just want him evaluated then for sanity?
Right.
All right, so
And,
you'll
but we're not positive on that because again, he's competent and we're trying to find a way. And again, I'm working with the state. We're trying to find a way that makes sense to get the right result in this case and not just check the box. Yes, he violated this statute and move on down the road. And so it's complex because he was homeless at the time and we want to make sure that the right result comes out.
All right, so Mr. Garza, we're gonna have to reset your case. Your attorney wants to get some more information so that he can better represent you, okay? All right, so you're going to then have to file the appropriate motion.
Right.
And it won't be through, the way they've changed things, it won't go back through to the magistrate's court.
It won't.
You'll have to get your own expert.
Okay.
Unless you're doing something where you're filing the motion for sanity, then it'll go back to the magistrate's court with one of their doctors. Otherwise, you'll have to
Right.
find one on your own.
I'll probably consult with the MAC office to see if they've got a recommendation as to the best approach for getting that opinion done.
All right, Ms. Ferguson, if you can recall this in 30 days, please. And you can just put it at discovery for defense to find more information on his mental health. All right, so we'll bring you back on August 19th. Do you have any questions about anything? All right, so if, I will tell you, if they're having you on meds at the jail, if you are having any type of side effects, you need to let them know or let your attorney know, okay? All right, so we'll bring you back on August 19th.
Thank you.
You're welcome.
Just have a seat, sir.
Who's here on Luis Alec Martinez?
I am, Your Honor.
You've been so patient.
I've been in the 379th.
All over.
Judge Nafeta for one case for about 5 hours yesterday and 5 hours today.
Ah.
I'm holding plea paperwork, Your Honor.
Mhm.
If I could give you an update before you, briefly, if I could just explain. Earlier this morning, I asked my client with your permission if he could leave to get the money orders. There is a dilemma about the funds available in his account, and
Okay.
there's a hold on funds. To help expedite this, a family member is going to help. I don't know if it'll be done tomorrow, but I'm holding 4 upfront restitution forms. Literally, once the money orders are paid to these 4 specifically, we have plea paperwork by the DA. DA signed it. It is not signed by the client. We don't have permission to go forward with it, but I don't want him to be in the same position tomorrow where there's a hold on a fund because a family member transfers something from one account to another. You have to wait for settling. Perhaps Monday, Tuesday,
Okay.
everything will be settled, transferred, and then he can get the money
You
ordered.
want to
from
put it on the 24th?
July 24th, Thursday. I'm available.
Mhm. Will that be done? And then, of course, counsel, since he's on bond, if you want him brought over sooner, just let us know.
Once the amount is paid.
Yes.
And because we have to pay it here at the courthouse, first floor,
Mhm.
maybe the same day that he pays it, we just come up to the 4th floor.
All right. Norma, on this case, if you can recall it for July 24th, please.
July 24th?
Yes. And it's for plea and restitution.
Thank you, Judge.
Okay, thank you.
Thank you.
You can have a
Yes.
seat back where you were,
Yes,
and once you get the recess form.
they had some issues with transferring funds.
Sorry about that, Judge. I was even there earlier today. Nobody said a word to
You
me.
were. I was like, he's there. James? All right, James Cody Davis. You were here.
I was. I even talked to the DAs and everything.
All right. So, Mr. Porter, today is, I think it's being, I know you were recently placed on this case. Let me see something. On this case, Mr. Porter, have you had a chance to review all the discovery yet?
Judge, can you know what, Judge, can I speak with the DA somehow, some way?
Yes, I can have them actually give you a phone call.
I would appreciate that, Judge.
All right. All right, thank you. Do you guys have his number? I do, yeah. All right, so they're gonna be giving you a phone call.
Okay, I'll zoom back on when I'm done, Judge.
All right, thank you. If you'll have a seat, sir. All right, thank you. All right, so. And Deputy Laura, could you make an announcement for Joseph Gilbert Montez Lee?
Gilbert Montez Lee?
Mhm. All right, and Duffy, are you available to do a couple of cases?
To do.
They're not present.
I can do any.
All right, oh, thank you. All right, the court is calling 2025 CR 0066564, 2025 006565, and 2025 CR 007325, State versus James Francis. State, did you have I'm sorry, State, if you could make an announcement
I'm James Frank.
for the record.
Oh, locked in the state of Texas, Your Honor.
It's okay, it's been a long day. All right, this hearing was scheduled at 9 a.m. Defense counsel did appear, but defense counsel informed the coordinator that he had had no contact with his client. It is now 4:09 PM. The deputy made the announcement outside for Mr. Francis. And deputy, was there any response?
No, Judge, no response.
All right, and he is on a commercial bond. State.
State would kindly ask for a bond forfeiture and a warrant, Your Honor.
All right, the court will issue a bond forfeiture in each case. Remand the defendant without bond. If he makes an appearance, the court will reconsider. The next case the court is calling is 2025 CR 007147, State versus Joseph Gilbert Montez Lee for the state.
Deputy Pitlock for the state of Texas, Your Honor.
Teresa Max Vasquez for the defense.
All right. And counsel, have you had any contact with your client?
I have not, Judge.
All right, the deputy made an announcement for Mr. Montez Lee outside. Deputy, was there any response?
There's no one out there, Judge.
All right, state, this is a PR bond.
State would ask for a bond forfeiture and to issue a warrant, Your Honor.
All right, the court will issue a judge's warrant and remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. Thank you, counsel.
No, ma'am.
All right, the court is calling 2025 CR 007447, State versus Ethan J. Castillo for the state.
Jesus, Your Honor, Your Honor.
All right, this hearing was scheduled at 9 AM. It's now 4:14 PM. The defendant did not make an appearance. The defendant is on a PR bond. State.
State requests judge warrant, Your Honor.
All right, the court will issue a judge's warrant, remand the defendant without bond. If the defendant makes an appearance, the court will reconsider. All right, Mr. Porter on Cody.
Yes, Judge.
All right, Mr. Davis, if you'll come down. All right, and where are we, Mr. Porter?
The judge, it's just odd not looking at you and looking at my client, but I understand. No, I need to turn something over to Miss Galloway, and it could affect the agreement. Can we recall him for next week?
Yes, when would you like it recalled for? And the court is aware that you were recently appointed on this case.
Well, yes, and that's why I've been digging through this stuff. But if we could do it, I want to say Thursday.
All right, Ms. Ferguson, can we recall this back on Thursday?
Yes, ma'am.
All right, so we're gonna bring you back on Thursday. Your attorney, as you heard, has some information that he believes may change the state's position.
And also, I just want to let Mr. Davis know I'll run by to the jail and visit with him.
Yes, sir, thank you.
You bet.
We're gonna bring it back on the 24th. That's the Thursday, okay?
Yes, sir.
Thank you, Judge.
All right,
Thank
thank
you.
you, sir.
All right.
All right, thank you, Mr. Porter, for zooming in.
Thank you, Your Honor. Bye-bye.
Bye-bye. Right. So on Victor Escobar. And counsel, are you proceeding?
Yes, Judge.
All right, the court is calling 2023 CR 11027A, State versus Victor Javier Escobar. Can I have parties announced?
Deputy Pitlock for the state of Texas, Your Honor.
Teresa Max Vasquez for the defense.
And are you Victor Javier Escobar?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, Your Honor.
Did you understand it?
Yes.
Are you the same Victor Javier Escobar who's placed on deferred adjudication in 2023 CR 11027A for the offense of burglary of a building on January 3rd, 2024 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Victor Javier Escobar did then and there fail to report to the supervision officer as directed for the month of March 2024 in violation of condition number 4.
How do you plead, true or not true?
True.
The state will waive and abandon the remaining violations.
Any objection?
No objection, Judge.
Did you understand by pleading true to violation of condition number 4, the court would find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, sir.
Knowing that, you still wish to plead true to violation of condition number 4?
True.
No, do you still wish to proceed
Oh, yes.
with your plea of truth?
Yes.
All right, so here's the thing. You may have an agreement with the state and the defense, but the court doesn't have to follow whatever agreement that you've reached. Do you understand? Because probation is a contract with the court. It's not a contract with your attorney or the contract with the state. Do you understand?
Yes, sir.
All right, the court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor, the agreement does not go in line with probation's recommendation, but we are recommending you grant the state's motion, adjudicate defendants. We're asking for a sentence under 1244A, 180 days, Bear County Jail.
All right.
That is correct, Judge.
Are you asking me to follow that agreement?
Yes.
Yes, sir.
Are you waiving your right to appeal?
Yes, sir.
All right. Probation, was there any restitution owed to the complainant, Andrew Fraught?
Judge, I don't think that.
All right. The court will follow your agreement, find you guilty. The court will sentence you to 180 days in the Bear County Jail under 1244. Give you credit for any time served. There's to be no contact with Andrew Fraught, Fraught. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing. I understand that this is the easy way out for you because you do your time, you're done. But now you have a conviction on your record. It's a felony. If you pick up another charge, depending on the level of felony it is, this may be used for purposes of enhancement. So this is going to follow you around wherever you go. You understand?
Yes, sir.
If you have a drug or alcohol problem, you better get a handle on that. Otherwise, you're going to find yourself spending a lot of time at somebody's jail and in somebody's prison.
Yes.
When you're released, if you are, going to really get sober and take care of everything and you can't find a place, a sober house or something, you can always come back here. If I'm here, I'll make sure I find a place for you, okay?
Yes, sir.
All right, good luck to you.
Thank you, Judge.
Thank you.
Just have a seat, sir.
All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct? And is that verdict unanimous? And did everyone sign the verdict form? All right, if you'll hand the verdict form to the deputy, please. Thank you. All right, if the defendant will please rise. The verdict form states, count 1. We, the jury, find the defendant Tyler Ashfall guilty of the offense of aggravated assault against a public servant as charged in count 1 of the indictment. Count 2. We, the jury, find the defendant Tyler Ashfall guilty of the offense of aggravated assault against a public servant as charged in count 2 of the indictment. Count 3A. We, the jury, find the defendant Tyler Ashfall guilty of the offense of deadly conduct as charged in count 3, paragraph A of the indictment. Count 3, paragraph B, verdict form. We, the jury, find the defendant Tyler Ashfall guilty of the offense of deadly conduct as charged in count 3, paragraph B of the indictment. The jury forms appear to be in proper order, and it appears to be signed by all the jurors. Which anyone wish to have the jurors polled? All right, ladies and gentlemen, I'm going to point to you and ask you if this is your verdict in each of the counts, and if you sign the verdict in each of the counts. If the answer is yes, I need everyone to respond yes. Does everyone understand? All right, we're going to start on the end on the front row. Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? We'll start on the back row. Is this your verdict? 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 All right. So ladies and gentlemen, what's going to happen now? It's almost 5 o'clock. We can start the second phase of the trial tomorrow at 9 a.m. or all right, I will have you all discuss it. All right. So if everyone will please rise for the jurors.